Good morning to you, ladies and gentlemen, and sorry for all the technical trouble we have encountered this morning. Hopefully there won't be any more troubleshooting, and I'd like to welcome you to a very special event because our conference crowns a project that I was pleased to manage and head. It featured the participation of our Lithuanian and Ukrainian partners, and we wouldn't have been successful had it not been for the human factor. So with that in mind, I'd like to thank all of my partners in crime, Professor Izarova of the Shevchenko University in Kiev, Ms. Krychina, also of the Shevchenko University in Kiev, and Professor Agnes of the Nicholas Romeris University in Vilnius, as well as Dr. Anna Cybulka of the University of Warsaw. Our venture did not necessarily have to be successful, but luckily for all of us, we are all here today, which is splendid for us, as we will be able to converse in all languages on mediation and other matters that are of interest to us. Thank you, dear colleagues, and I'm sorry in advance for my imperfect English, for my stress and tiredness, but I'm nonetheless delighted to have been able to work with you. And so far we have been pen friends only, and now we will make actual friends in person. So thank you for being here. Our program, which summarizes the research findings of our project, will be supplemented with splendid speeches and presentations by hand-picked panelists from Poland, whom I'd like to welcome wholeheartedly too, and whom you'll be able to hear in just a moment. And hopefully we will also have, as promised, another presentation from the MRU University in Vilnius, Dr. Julia Radanova, who unfortunately got stuck in Munich. She is still very much stuck at the airport, but she's looking for a spare flight that will take her here in time for her presentation. Julia told me once, and she's Bulgarian, even though she works at a Lithuanian university in Vilnius. She once told me that Bulgaria introduced possibly the worst mandatory mediation possible and imaginable, and I thought we would be curious to learn more about that, and hopefully we will. I shall also welcome our colleagues from Ukraine, those of them who turned up here in person, and those of them who are waiting online. Unfortunately, we will not be able to connect live, but we will do our best to provide them with high-quality recording of this meeting. And so, hopefully, once you hear me in the future, while playing this recording, let me apologize once more for being unable to be with you online, and I'd like to give the floor to Professor Tomasz Nieborak, the Dean of the Faculty of Law and Administration now. Madam Professor, dear ladies and gentlemen, dear conference participants, dear audience, and dear online participants, I'd like to greet you live. That's not possible today, but hopefully you'll be able to pick up the recording sometime in the future once we eliminate all the trouble of technical nature. And I'd like to welcome you all in the confines of our Faculty of Law and Administration of the University in Poznań at the Child's Participation in Mediation Polish, Lithuanian and Ukrainian Perspective Comparative Law Research Conference. And it was with great pleasure that I accepted Professor Joanna Mucha's invitation for this conference because it concerns a tremendously important topic of child well-being and the child's best interest. Our today's conference is an international event and features participants from Poland, Lithuania and Ukraine. And dare I say, ladies and gentlemen, at the time of intense trouble, when we depart, or some of the values that we profess have been breached, we're dealing in a situation where unity is of paramount importance among us, as it is conducive to growth and well-being of all of us. This is particularly important with regard to children because all of us were once a child, and child's welfare and our care for their well-being does impact the world. And I'm speaking this as a dean of the Faculty of Law and Administration here, but also as a father of two who has been observing them on a daily basis and their growth as they develop, and I always appreciate the beauty of children as well as their openness, their sensitivity and a peculiar naivete and curiosity of the world which they have to face and whose rules and regulations they have to run into, including some conflicts, unfortunately, in which they are involved. And with that in mind, it is all the more important for the institution of mediation to keep growing and cater to children's sensitivity, while also introducing them to different facets of adulthood that they will have to bear and take upon their shoulders. The international aspect of this conference cannot be stressed enough. I'd like to welcome our colleagues from the Ukrainian and Lithuanian universities, and let me express our true gratitude for this collaboration. We keep learning from each other, we keep exchanging our best practices and experiences. We've already addressed some of them, and we are pooling our knowledge and traditions today. And I think we can agree that the history and tradition of our three states is inseparably joined and invites comparisons and different exchanges on various topics. And last but not least, I'd like to thank everybody involved in the organization of this conference. In particular, on behalf of the faculty, I'd like to thank Professor Joanna Mucha, who, as you might know, is also in charge of the Center for the Support of Mediation at the Faculty of Law and Administration at the University, which has been developing very robustly in the past few years. And the center will soon be able to avail itself of a spanking new office space nearby, which you may be able to see later on. I wish you a fruitful conference, great debates, and more similar projects in the future, and enjoy your stay in Poznań. Thank you very much.
Thank you so much, Mr. Dean. The first speaker was to be Professor Radanova, but because we are pressed for time, we will reshuffle a little bit the order of presentations, and let's have the panelists of the first panel here at the table.
Myślę, że zaprosimy do stołu panelistów z pierwszego panelu, panią profesor Irenę Izarową, panią Angelę Kryczynę.
Please join me on stage, Dr. Cybulko as well.
Wzięła na siebie obowiązek
who has the pleasure to
Przyjemność.
to be the panel moderator. Thank you, the chair of the panel.
Dziękuję bardzo.
Hello, a very good morning to all of you. I'm really thankful for being able to be the first speaker, somewhat out of order. I'm really thankful for this reshuffle. Today we're going to have a visitation from the university accreditation body today at my university. And that's why I would like to be the first speaker. Later today, we're going to talk about the psychological, practical aspects concerning the participation of children in mediation proceedings. My speech will be dedicated
poświęcić aspektom prawnym z perspektywy polskiej, ponieważ ta kwestia
we will basically, I will focus on general legal provisions on the status of the child in mediation. I'd like to kick off with the fundamental question of whether to include the children in mediation proceedings at all. Here we have a typically legal solution. The answer is both affirmative and negative. And the fundamental question can be answered in both ways. There is no foolproof method. It all depends on the situation at hand. There will be situations where the inclusion of the child in mediation proceedings will be very much needed in the best interest of the child and in the best interest of the child's family. But there might be situations where the child's inclusion into mediation proceedings will be far from beneficial. Now, if the child is included in the mediation proceedings, the child can be either the party to the proceedings, namely, the child can be an independent party and can take decisions on the agreement if the child has the right to perform legal actions. All of this is regulated by the civil code. In the other cases, where the child is not a party to the proceedings, the child has to be represented by an authorized entity, that is the parent, the carer, or the legal guardian. We are talking here about the provisions of the Family and Guardianship Code. If the court refers a given case to mediation, we will also deal with provisions of Article 65 through 66 of the Code of Civil Procedure. From the perspective of the child as a party to the proceedings, to the mediation proceedings, let me refer you to the amended regulations from which have been in force as of August this year, concerning the representation of the child when none of the parents can represent the child. In those cases, the legislator amended earlier legislation, introducing new terminology. The guardianship court appoints a representative of the child, a child's representative who represents the child in mediation proceedings when parents, for the sake of different limitations resulting from a relevant provision of the Family and Guardianship Code, cannot represent the child. In a situation where the child is a party to the proceedings, so this we've already discussed. There are also situations when the child is not directly affected, is not directly taking part in the proceedings. The child is a so-called hidden client, but obviously is affected by the solutions proposed in a particular case. In a particular case, the child does not have to have the capacity for legal actions. These consideration. This is of no consideration. However,
Te kwestie nie mają żadnego znaczenia.
the participation of the child in mediation is in the best interest of the child, is related to the child's age and mental state. In all those cases, we don't have specific legal regulations that would be related to this. To the child's status in mediation proceedings as a hidden client. Here we don't have specific regulations. We will proceed under general regulations. The best interest of the child is defined in Article 72 of the Constitution of the Republic of Poland, which and also the UN Convention on the Rights of the Child, and different other legal provisions. In international law, obviously, we proceed in line with Article 3 of the UN Convention on the Rights of the Child. Usually, what is specified here is the inclusion of the child in proceedings in common courts of law. And in other procedures. In my further reflections, I would like to tackle some selected issues because of time considerations. The first aspect to be addressed is the provisions of the Code of Civil Procedure and the participation of the child in mediation. As I was saying, the provisions themselves do not explicitly refer to this particular situation. However, under general rules, Article 183, Section 1 of the Code of Civil Procedure, mediation is...
Z zasady dobrowolności mediacji wyprowadzić wniosek, że możliwe jest także włączenie dziecka do mediacji. Także pomimo tego, że nie mamy jakiegoś szczególnego przepisu, to jak
it doesn't depend on the parties only. The child can be included in mediation. When it comes to the cases that the child should participate in proceedings, here we can refer to the general provisions of the Code of Civil Procedure, Article 10. Mediation proceedings can take place in all civil cases in which a court agreement can be concluded. So, in other words, it will all depend on whether the parties can freely dispose of the object of the contention of the dispute, or whether they can strike an agreement. Apart from that, in family cases where the children are very often part of, we apply the provisions of Articles 442, 445, and 470 of the Code of Civil Procedure related to separation and divorce. When it comes to situations when a child should be part of mediation, it seems that the inclusion of the child is fully justifiable when a court agreement directly affects the legal status of the child. This is basically in non-property issues related to the child's residence, choice of schools, and so on and so forth. In all the other cases, namely in
czy chociażby kontaktów z dzieckiem, prawda, opieki nad
mediation under Article 436 of the Code of Civil Procedure and property issues, the participation of the child is not justified and needed. Children do not need to be part of the disputes between their parents related to property, disposal of property, or other similar issues. Another issue I'd like to draw your attention to is the need to receive parental approval of the child's inclusion in the mediation procedure, which is directly linked to the
mediacji wyrażonej w artykule 183 z indeksem 1 paragraf 1, a także z zasady autonomii.
Okay, to the voluntariness of the child's participation in mediation proceedings. If the parents have no parental rights, the approval has to be gotten from the curator or guardian who fill in the parent's role, as well as in situations related to contacts with the biological parent who no longer have legal rights to the child. Let's move on to the aim and forms of the participation of the child in mediation proceedings. First of all, we want to hear the child.
Wchodzi tutaj w rachubę kwestia konsultacji z dzieckiem, postanowień ugody, które go dotyczą, i poinformowania dziecka.
And here we have a number of legal provisions which are both domestic and international, related to the child having the right to be heard. Article 12 of the UN Convention on the Rights of the Child. We can also invoke Article 72 of the Polish Constitution, Article 576 of the Code of Civil Procedure, and as of next year, we can also relate to Article 95. Of the Family and Guardianship Code. I would like to pause for a while and discuss Articles 216 and 216.1, 216.2, the ability to listen to the child, using the provisions, the legal provisions. We can extend the principle to mediation as well.
Z tych podstaw prawnych możemy tą zasadę rozciągać na mediację. Jeśli chodzi o kwestię wysłuchania dziecka, to tutaj interesującym problemem jest zachowanie zasady.
Now let me say a few words about the right of the child to be listened to and the confidentiality principle. Here, under Article 259, the mediation secrecy, the mediator cannot be a witness to the facts which they learned under the mediation proceedings, unless the parties release them or redeem them from the obligation to hold certain matters in secrecy. This is a kind of discrepancy. We can say that the provisions do not actually protect the child. They do not fully realize the principle of the child's protection, because the child can be an object of some tug of war between the parents in judicial proceedings, and the decisions are made by the parents who are parties to the proceedings. So if the conflict is, say, intransigent, and then
tak nasilone, że rodzice nie
the best interest of the child is not protected under judicial proceedings later. When it comes to the child's right to be notified of the solution to mediation proceedings, we don't have direct provisions related to it. We have an indirect obligation which stems from Article 13 of the UN Convention on the Rights of the Child and Article 3 and 10 of the European Convention on the implementation of children's rights, drawn up in Strasbourg in 1986. Article 133 does not envisage a situation when
Natomiast w pewnych sytuacjach możemy
we may have two situations where a court agreement or the mediation agreement is in contravention of the law or in contravention of principles of social well-being.
jako podstawy do odmówienia nadania klauzuli wykonalności lub zatwierdzenia ugody.
As for the form of mediation proceedings with the inclusion of the child, one of them is less often used and less desirable in the presence of parents. Different methods can be applied here. One of the drawbacks of the solution is that the child can be potentially felt as a person who needs to opt for a particular side or for a particular child. We believe that this is undesirable. Far more beneficial from the point of view of the child is to have mediation with the participation of the child without the inclusion of the parents, or in the absence of the parents, the mediator can talk with the child unless they are, as long as they are qualified. And the other model, another model which is often used is a meeting with a psychologist in the presence of a psychologist who has enough expertise in
ma doświadczenie, ma wiedzę w zakresie rozmawiania z dziećmi i następnie
gleaning information from the child. The last question I would like to address is the use of the so-called children's advocate in mediation proceedings. We need to realize that the child's participation in mediation proceedings can be direct. The child is personally present in mediation proceedings, or the child's participation can be indirect. That is, the child is not directly participating, but we have another entity who is tasked with the protection of the child's interest, and this is the situation when we deal with so-called child-oriented or child-focused mediation instead of child-inclusive mediation with the direct participation of the child. Now, when it comes to the participation of the child's advocate or the guardian of the best interest of the child, here we have a whole host of different solutions. We first need to identify the conditions, the criteria under which the child's advocate can participate in mediation proceedings. So once again, we may invoke the principle of the best interest of the child. The child's advocate's participation calls for the approval
To też wynika z tego, że w ostatecznym
of the child's advocate. The child's advocate's participation is contingent on the approval of the parties to the proceedings, because they actually also pay remuneration to them. Who can be the child's advocate? Can it be the mediator, him or herself, which is not the ideal solution, because the mediator should not really focus solely on the protection of the child's best interest. The mediator has a whole set of different responsibilities. It would be better if it were a child's representative, another family member, a psychologist, or still another person, and in such a case, we say that the mediation itself is quadripartite, you can say. Now, what is the role of the child's advocate? They take care of the child's best interest during the mediation proceedings in relationship to the mediation agreement, and in conclusion, we can say that from the legal perspective, we don't have direct provisions related to the participation of the child in mediation proceedings. However, we do not need to see this as a drawback of the solutions. The flexibility of the current solutions allows us to both include the child in mediation proceedings or to proceed without the child's presence during the proceedings. If, however, we were to zoom in on the areas where the child's participation is justified, we first of all need to listen to what the child has to say, and possibly this regulation might be introduced. Another area is the secrecy, the confidentiality of the information obtained from the child, and finally the participation of the child being a reason for the refusal to conclude an agreement in court. I believe that in absence of these regulations, that the absence of these regulations puts an additional burden on the mediators. Thank you so much.
Na te kwestie uwagę. Dziękuję.
Thank you very much, Dr. Skibinska, and unfortunately Dr. Skibinska must run some urgent errands, so she will leave us, and there's no time to Q&A, Dr. Skibinska, and unfortunately we are running short of time as a panel in general, so we will move the Q&A to the coffee break, and so for now I'd like to depart from the Polish legal context, which is part of the framework we will be operating under today.
podejmują, żeby zmierzać do ochrony dobra dziecka.
I'd like to focus on Ukrainian context, so we shall give the floor to Professor Irina Izarova, who will speak on mediation as one of the main steps to child-friendly justice development in Ukraine.
Dear colleagues, dear Anna, yes, I know, thanks. Thank you very much. I'm very pleased to be here today. I'm very sorry for these technical issues. This is a wonderful event. I'm very grateful for the invitation from Professor Joanna Mucha, and thank everyone who helped to organize our meeting. The topic of my presentation is related to mediation, but more details will be provided in her speech by Ms. Angela Krycina, my colleague and PhD student. I want to focus on the issues of child-friendly justice, and it's specific in Ukraine. Boss, Angela, and me. And I enthusiastically accepted the invitation from Professor Mucha. Firstly, we both love children, of course, very much, and we are clearly interested in fully implementing the principle of safeguarding their best interests. Secondly, in our society, there is an evident need to reconsider some outdated approaches to regulating relations involving children, especially in procedural law. Simultaneously, focusing scientific interests solely on issues of judicial protection is too narrow today. Hence, the question of children's participation and alternative procedures appeared incredibly appealing. The prepared survey questionnaire provided clear opportunities to comprehensively and objectively assess the practice of Ukrainian mediators regarding children's involved in mediation, exploring their opinions, and more. Intermediate conclusions from the gathered results were published in our joint article titled Towards the Implementation of the Best Interest Principle in Child Mediation, Ukrainian Experience. Ms. Angela will provide more details about our findings. At the same time, for my presentation, I choose a slightly different focus, which will hopefully clearly demonstrate my stance on children's participation in judicial procedure, particularly in the aspect of implementing the best interest principle for the child. Наступне. So my main question is there room for kids' participation in dispute resolution? I mentioned society's request in vain in the introduction, and how I want to draw your attention to how the world around us is becoming an inclusive one, where everyone has the right to respect and the rights of each are protected. Следующий. The Declaration of the Rights of the Child and the Convention on the Rights of the Child are important instruments whose provision must be implemented in practice. Their adoption marked an evolutionary step in humanity's understanding of the peculiarities of childhood, the importance of ensuring the normal development of the child, and the necessity of introducing special approaches to ensure protection of children's rights. At the same time, I want to draw your attention to the fact that only in 2002, the child delegates first addressed the General Assembly of the United Nations, and the World Fit for Children agenda was adopted to define specific goals for improving children's life in the years to come. Only 43 years after the adoption of the declaration did we manage to give a voice to children. In this historical paragraph, you can see representatives of photograph, you can see representatives of child delegates at the United Nations. Among the goals of sustainable development, much attention is devoted to the needs and issues of children. In particular, I would like to draw your attention to goals such as no violence and establishment of a child protection system. In recent years, the concept of child-friendly justice has gained momentum, manifesting itself in aspects such as accessibility and age appropriateness. The Council of Europe guiding principles on child-friendly justice were developed by a group of specialists after extensive consultation with nearly 3,800 children across Europe. The ultimate results in a set of instructions aimed at improving children's access to justice and their treatment within the legal system. The recommendations establish fundamental rules that European states should adhere to when adapting their judicial system to the specific needs of children. They apply under any circumstances in which children may, on any basis and in any capacity, come into contact with the criminal, civil, or administrative justice system. Their recommendations promote the principle of the best interests of the child, care, respect, participation, equal treatment, and of course the rule of law. Следующий слайд. It's a pleasure for me to tell you about the European Commission funded project, particularly Justice Child-Friendly Network, Child-Friendly Justice European Network, which consists of almost 30 expert organizations and individuals advocating for child-friendly justice, serving as a unique and powerful voice in 19 European countries. This network was established in 2019 and in Belgium, and since 2022, thanks to the financial support of the European Commission, was officially launched as a fully operational working network. And as you can see, there are representatives from Poland and Lithuania in this network. The purpose of this network is very simple. Children come into contact with the justice system in many different ways. This can be for family matters, divorce, adoption, and other matters as well. They may also need to reach a justice system seeking for remedies with their rights are not fully respected. However, respect for children's rights in the field of justice for children is relatively heterogeneous. While all European countries have signed and ratified the United Nations Convention on the Rights of the Children. Furthermore, child justice system in European countries remain insufficiently adapted to children. Justice institutions and professionals are not sufficiently trained when they come into contact with children. So adapting the justice system to their needs is a necessity for now. In 2021, a consortium, this network, consulted 40 children to influence the strategy on the rights of the child. Comparing, for instance, when asked about how child-friendly they perceive justice system to be in Europe, child unequivocally express their feelings of injustice. For instance, they talk about indifferent and insensible position to their situation. They felt that they were not worthy of interest and care, very poor level of legal information and other things. So, следующий slide. Adapting justice system to the child is very important to create such system with guarantees, respect, and the effective implementation of all children's rights due consideration to the child level of maturity, understanding the circumstances of the case. Ukrainian overall shares the aspirations and concerns expressed by children regarding professionals who interact with them. These considerations based on the results of the analysis of our Ukrainian case law. For instance, I would like to tell more about a few positions of our Supreme Court. Now, it's very difficult cases with involving parents and children. For instance, in this case, it was very clear position of our Supreme Court announced because children should be heard, and if a child is capable of formulating his own views, he should be she should be provided with the right to freely express these views on all matters that concern him or her. Just a few cases and examples of other positions of our Supreme Court, because child's consent to live with one of the parents should not be absolute, because for the court it's very important to find the truly equal decision between parents and child rights and interests in this matter. We have, for instance, a clear rule of a family code, of our family code of Ukraine, where the exact age of kids mentioned up to 10 years, after 10 years, from exactly 10 years till 14 years, when a kid should be absolutely mandatory asked about his or her opinion concerning the matter, for instance, determination of a place where exactly should be the place of the residents. We have just a few cases, but very remarkable. For instance, Savini against Ukraine, about, unfortunately, our national courts, I would not say ignored, but it was not clearly mentioned that court consulted with kids' opinions during the trial, unfortunately. Analyzing the practice, for instance, by one of our organizations, they analyzed more than 200 cases with involving kids in trials, and as you can see, 75% of these court decisions do not contain data on ascertaining the child's opinion in any stage of the process. The court decision in 19% of this data contains information about the child opinions was clarified in court or at the pre-trial stage. So, for instance, it's absolutely understandable when court does not request an opinion of a child who did not reach the age of 3 years. Significantly small cases, just 8% cases among children from 3 to 6 years. But in the vast majority of cases, the courts neglect the law instruction, as we mentioned, to take into account the opinion of child who has reached the age of 10. So that was a question why, and we discussed it with colleagues and reached some conclusions about it's not very easy to question a kid even if they reach the age of 10 in a trial, according to our law, because we have not confidentiality, and if in this case involved parents who are disputing parties, it's very hard to deal with them and to keep safety for a kid who want to express their opinion to the judge, to the court. Next one. As you can see, most the child opinions was yeah, we talk about that. Next one. This examples of adoption cases. It's very important cases, and as you can see, even in such categories of cases, only in 20% where it is possible to find out the child's opinion, children are invited to court to find out their consent to adoption. Almost 50% of cases where the child's opinion can be uncertain, the child's consent to adoption is not uncertain, either in court or at the pre-trial stage of the procedure, unfortunately. Следующий. So, guiding principles of Council of Europe. I would not say we are following these guiding principles fully, and especially it's about listening of children's views and opinion by court. And the next one. And timing of the procedure, because it's very important. If you have noticed timing and the length of the procedures, it slides with decisions of our Supreme Court. Is absolutely normal for trials to take longer than 2, 3, 4 years. For a kid of age 8, 9, 10 years, it's significantly long duration and long period of time. Next one. Of course, all this the situation with adapting of the justice system to the child-friendly guiding principles is much more difficult with the situation with war in Ukraine. Even we are the contracting party to the Hague Child Protection Convention. I have to admit that European Justice Portal just in first first period of time plays this instruction about children from Ukraine and civil judicial cooperation about that. Unfortunately, a significant number of Ukraine's children have been forced to flee their homes due to the war. They have fled alone, exposing them to abuse, abduction, exploitation, human trafficking. And here you can see 6 Ukrainian children testified in the Hague criminal court about life in captivity and the crimes they witnessed. To identify Ukrainian children abducted by Russia, the Netherlands will help create a database for DNA. This would also add to the International Criminal Court and very important activities of these kids. Instead of very wide conclusion, I would say not only to ensure full implementation of the best interests of the child principle, but also to make efforts is required. I agree with all the proposals made by this wonderful network. We must double our efforts to adapt the justice system for kids, because children are our future, and there are so many very useful things they shared with us recently. Art provides us an opportunity to showcase what is important and extremely relevant. I want to come back to the society's demand for change. Today's demand pertains to children, and as you can see the film, this year Palme d'Or winner of the Cannes Festival is about a child in a court, and thanks it's French court, not Ukrainian. This is an impressive masterpiece and explores this justice system and a child who is far from blind. Often this child sees the truth better than others. I sincerely wish success to Professor Mucha's cause, to all the mediators and professionals who see the potential and necessity of child-friendly justice development. And I rather agree with the ideas of mediators, a friend of kids in dispute resolution. I would like to thank all of you for listening to my presentation and ask you to listen to the next presentation of Angela Krishina with more our results of our findings.
Okay, thank you very much, Professor Izarova, for this most interesting presentation. And it's most interesting to listen to the changes of the justice system and the adaptation of the system to the needs of children. I think it's very useful to see how it works in different countries. And so I would be also most interested to hear about the results of the research. So now I would ask Ms. Angela Kryczyna from Taras Shevchenko National University of Kyiv, and the title of the presentation would be Opportunities of Family Mediation in Implementation of the Principle of Security Best Interests of the Child, Ukrainian Experience. So this is one of the 3 parts of the research.
говорити українською мовою, і пані Ірина
I'm going
згодилася.
to talk Ukrainian, and Pani Irina will help me with translation to English.
Так. Для мене велика честь бути тут разом з вами і представляти результати дослідження цього проєкту, які були проведені в Україні. І я хотіла би не лише зупинитися на цих результатах, а й розказати вам про сьогодення спільноти медіаторів в Україні. Мені важливо було би також трошки розказати вам про правове регулювання цієї процедури в Україні і розказати саме те, що було предметом дослідження, а саме про сімейну медіацію як інструмент реалізації найкращих інтересів дитини. І, зрозуміло, у нас зараз війна, тому я трішечки зупинюся на цій темі, які виклики постали перед медіаторами в умовах війни.
It's a great honor for me to be here and to be part of this large-scale study and present its results at this conference. I would like to talk about these results, about specifics of the mediation in Ukraine. I would like also to sketch a few things about the current mediation in Ukraine right now amid war.
У мене була можливість вчора поспілкуватися і познайомитися з колегами з Польщі. Це була дуже
Yesterday,
приємна.
I have a great opportunity to talk with my colleagues from Poland, mediators.
Це була дуже приємна і тепла зустріч, за що я дуже вдячна їм.
It was a very pleasant and warm meeting, and I am very grateful for that.
Я хочу трошки зупинитися на тому, що наша медіація в тому вигляді, яка вона є зараз, вона вже виникла ще з 90-х років.
I would like to tell you about mediation in Ukraine, and in this current state, it was born in far away in 19th.
Розвиток здійснювався різними шляхами. Разом з тим, зараз це однозначно позасудова процедура.
The development was carried out in a various way, including through the judicial system, but today this procedure exists and it's developing as an obviously out-of-court method of resolving disputes.
Станом ще до війни в нас вже було більше 30 приватних організацій.
Even before war, we have more than 30 private organizations of mediators.
Дуже багато громадських організацій, які саме розвивають і працюють в питаннях щодо розвитку процедури, щодо її становлення і розповсюдження в Україні.
There are many public organizations among them who are working on the implementation, development of the procedure of mediation, of the regulation of mediation in Ukraine.
В нас є організації, які об'єднують всіх медіаторів.
We have an organization that unite all mediators in Ukraine.
Наприклад, це Національна асоціація медіаторів України.
The National Association of Mediators of Ukraine.
Крім того, у нас є організації, які об'єднують медіаторів за спеціалізацією. А я лістаю, да. А презентації немає. Вибачаємося.
We will share all the presentations after.
В мене вона рухається.
Давайте далі.
Зараз я хочу, щоб все ж таки були. Ага. Це є. Це
This is
те,
the
да.
National Association of Mediators of Ukraine.
А крім того, в нас є організації, які об'єднують лише медіаторів, що спеціалізуються на певній медіації, наприклад, сімейній.
Also, we have organizations that unit specialized mediators, for instance, family mediators.
Це такі, як, наприклад, Асоціація сімейних медіаторів України або Ліга медіаторів України.
For example, the Association of Family Mediators of Ukraine or League of Mediators of Ukraine.
Така організація, як Центр медіації та посередництва, яка є структурним підрозділом державної установи, вона спеціалізується на медіації в інтелектуальній власності. щодо спорів в інтелектуальній власності.
For instance, we have also an organization, mediation and facilitation center, which is a structural subdivision of the state organization, Ukrainian National Office for Intellectual Property and Innovation.
В Україні медіатори можуть бути членами або однієї організації, або декількох одночасно.
In Ukraine, we have no restrictions, so mediators could be a member of one or more organizations of mediators.
Може практикувати приватно.
Mediators also can practice privately without any affiliation with association.
Угу. І після російського вторгнення багато медіаторів були разом зі своїми сім'ями і в зв'язку з втратою домівок були вимушені або переїхати в межах країни, або виїхати за межі України в інші держави разом з сім'ями і дітьми.
After the Russian invasion, the community of mediators in Ukraine was scattered around the world as due to the loss of homes. Looking for safer places for their children and relatives, they were forced to go abroad together with millions of Ukrainians, where they were essentially forced to start their practice from the beginning.
Де вони намагаються співпрацювати з медіаторами інших держав або починають все з нуля.
They tried to cooperate with mediators, with foreign mediators in their country of residence, or try to start everything from the very beginning.
Правове регулювання медіації в Україні воно було досить тривалим таким, і були різні перепони.
The legal regulation of mediation in Ukraine has been formed gradually and for a long time.
У нас було 15 законопроєктів перед тим, як прийняли закон.
Actually, we had 15 drafts of law on mediation in Ukraine before adopting it.
І нарешті в 21-му році у нас прийняли профільний закон України про медіацію.
Only in 2021, in 16th of November, the relevant law of Ukraine on mediation was adopted by Parliament of Ukraine.
І за висновками іноземних і національних експертів, цей закон є рамковим і відповідає міжнародним стандартам медіації.
According to the evaluation of foreign and national experts, this law comply with the international mediation standards fully.
Але такий поштовх в розвитку медіації і можливість до закону надавати цю послугу була завдяки закону України про соціальні послуги.
The first push for regulating mediation in Ukraine was the state standard of social mediation or mediation services approved in 2016.
І державний стандарт соціальної послуги посередництва. Да? Угу. А крім того, у нас вже розроблений і діє кодекс етики медіаторів, і в його прийнятті приймала участь майже вся спільнота медіаторів України з різних організацій, і ті, які приватно практикують, і ті, які в організаціях або в громадських організаціях.
It was a great achievement for all the community of mediators of Ukraine to develop and to adopt a code of professional ethics for mediators, which introduced basic ethical standards and guidelines for the quality of service provision for both mediators and parties to the procedure. And almost all the mediators were involved in this process of preparing and adopting it.
І у нас дуже велика увага приділяється якості послуги, і відповідно до закону у нас медіатор повинен мати 90 годин навчання.
In Ukraine, a lot of attention is paid to the quality of mediation services, which in turn is influenced by the quality of the mediator's training. According to the law, the basic training of a mediator is carried out according to the program at least 19 hours.
І крім того, 45 годин з цих – це обов'язково практичні навички і їх відпрацювання.
Half of this 45 hours of practical training should be is mandatory.
Отже, і зараз, незважаючи на пандемію, на війну, все одно медіація в Україні розвивається. І
Despite pandemic and the war, the mediation in Ukraine is developing right now.
І завдяки цьому проєкту нам вдалося узагальнити досвід саме українських медіаторів, сімейних медіаторів.
It was a great success to participate in this project and to generalize practice of Ukrainian mediators with mediation with participation of kids.
Да, і опитування медіаторів, воно було ще до війни за досить нетривалий час.
As you can see, the survey of family mediators in Ukraine within this project was conducted shortly before the war, the full-scale war started in October till December of 2021.
Мій перекладач за мене каже, дати. Дякую, Ірина. У нас в опитуванні взяли участь 70 медіаторів, які прийняли участь в цьому дослідженні.
We had 70 respondents who took part in this survey.
Як ми побачили, це 80% це жінки і 20% це чоловіки.
80% are women, 20 are men.
І завдяки цьому дослідженню ми побачили, що переважність респондентів – це люди від 35 до 55 років.
With the majority of people aged 35 to 55 years.
Практичний досвід у більшістьох медіаторів – це 3 роки.
The majority of mediators who took part in this study have up to 3 years of practical experience.
Що нам дало бачення того, що медіація фактично як послуга більше почала розвиватися і має попит лише останні 5 років. З урахуванням цих 2 років війни. На час, коли проводилося опитування, це було 3 роки.
This may indicate that mediation has become more well known and gained popularity in society over the past 3 years. So, keeping in mind that it was 2021, right now we can count 5 years ago.
Я вчора спілкувалася з нашими колегами і зрозуміла, що ми, в принципі, практикуємо приблизно однакову процедуру.
As far as I understand from my conversation and discussion yesterday with my colleagues mediators from Poland, I clearly understand that we practice almost the same similar ways of mediation.
Ми також проводимо консультування про процедуру, індивідуальні зустрічі і спільні.
We also practice individual meetings about mediations with parties.
І щодо кількості медіацій в місяць, то більшість проводить по одній медіаційній процедурі в місяць.
The average number of mediation per month it's up to 3.
А по одній в місяць. Але процедура може складатися з декількох зустрічей.
One meeting per month.
І лише 20% медіаторів, вони мають більше, ніж 6 процедур медіації в місяць.
Only 20% of mediators have more than 6 meetings per month.
У нас медіатори, більшість медіаторів зазначили, що вважають, що обов'язково треба, щоб думку дитини була доведена до відома батьків, але без вимагання того, щоб це було включення, без рекомендування того, чи хочуть вони це включити в свою угоду.
All mediators, to one degree or another, believe that child's point of view should be taken into account during mediation. And the majority of respondents noted that the wishes and expectations of child should be voiced to the parents during the mediation procedure, without requiring their inclusion in the content of the settlement agreement.
Більшість медіаторів зазначають, що важливо, дуже важливо знати думку дитини, але з обережністю ставляться до того, що дитину треба залучати безпосередньо до участі у медіації.
Despite the fact that the majority of mediators consider the child's participation in the mediation procedure to be quite useful, they do not see the need to involve him or her in resolving issues. Also, they will affect the child's situation, do not relate to his/her personal rights and interests.
Розуміючи, що для роботи з дитиною треба певні навички, щоб не нашкодити дитині.
Keeping in mind that for working with kids, mediators should have necessary skills and abilities to work with kids.
Наші медіатори вважають необхідним здобувати додаткові навички і навчатися на спецкурсах по роботі з дітьми.
The majority of respondents answered about the necessity of additional qualification trainings and professional support for working with kids.
І мені вже кажуть, що пора закінчувати, але я хочу продовжити. І такі курси у нас є. І, наприклад, це сімейна медіація за участю дітей надається у нас тренінговим центром «Школа медіації».
Such specialized trainings is provided by several training sessions conducted on an ongoing basis. For example, the Ukrainian Mediation Center has a specialized course, basic training of a family mediator, and basic skills for a family mediation with participation of children.
І за результатами цього дослідження ми прийшли до думки, що треба певні рекомендації розробити щодо можливості, яким чином вислухати думку дитини і які категорії справ можливо рекомендувати або суддям, або іншим правникам для того, щоб хоча б сторона отримала інформацію про нашу послугу.
We have reached to the conclusion that practically we seek support and recommendations in which category of cases kids should be involved and how to work with them in more details.
В зв'язку з викликами, які зараз стоять перед медіаторами, то ми шукаємо нові шляхи для того, щоб забезпечити права дітей і права наших клієнтів. Як ви бачили на останньому слайді, зараз проводиться 4-годинний і вже реалізований 40-годинний навчальний курс по підготовці сімейних медіаторів для посередництва в транскордонних справах.
Due to the situation with war in Ukraine, we need some more support for professional services of mediation for such kids. A 40-hour training course can be prepared and being implemented to train family mediators to mediate cross-border family disputes between Ukrainians, taking into account the specific of wartime, including cases of international child abduction, access to children, and guardianship.
Зараз у нас змінюються підходи трохи до самої процедури.
Now we are changing the regular approach to the very procedure of mediation.
Більшість медіацій проводиться в форматі онлайн.
Majority of mediation plays online.
Через фінансову нестабільність людей більшість медіацій про-боно.
Due to financial situation of parties, a lot of mediation procedures makes pro bono, so without payment.
Перша зустріч, як правило, вона триває довше, ніж зазвичай, бо перше питання, яке ми ставимо, це чи знаходитесь ви в безпечному місці.
The four questions we ask our parties is, are you in safe place right now?
Зрозуміло, що більше працюємо зі станами людини, психоемоційними станами людини і своїм також.
Right now we are working more with psychological condition of parties as well as mediators.
Разом з тим, ми зараз шукаємо нові, удосконалюємо ті механізми, які у нас є, і медіація все ж таки продовжує і розвивається.
Anyway, we are developing, we are looking for new approaches, new ways of dealing with these cases, and
Дякую вам за увагу і буду рада з вами поспілкуватися, можливо, на каві-паузі.
Thank you very much. I would be happy to answer your questions and to discuss these things.
Thank you very much for this great insight into the practice of Ukrainian mediators, especially during this very hard time of war, which makes it very special for sure. So,
Ladies and gentlemen, this is officially the end of our first panel, and now we are going to have a 20-minute break to refresh and to carry these discussions outside of this room, and we shall reconvene in 20 minutes sharp for our second panel. Thank you very much.
Proszę Państwa, możemy powoli zacząć. Tak? Dobrze, cieszę się bardzo. O, to na szczęście.
Very well, ladies and gentlemen, let us begin the
Może powiem Państwu, jak
second panel, and let me brief you on the agenda. After some necessary changes, we will start with Professor Agne Twarow-Nawidziene. Okay, and this will mark the end of the English speaking part of our conference, unless Agne wishes to speak Polish, which she's exquisite at.
jest w tym znakomita. Później ja przedstawię
Then I shall present some of our findings resulting from our project, and then we shall connect to Professor Czeredecka, who was supposed to join us online and who will speak on the social aspects of including children in mediation, and I'm sure she will be of great interest to you. And we shall conclude with Dr. Cebulko's presentation, who will speak on a comparative, on a legal comparative perspective on including children in mediations.
Zapraszamy, Agne.
Tak to, dzień dobry. Bardzo mi szkoda.
Thank you for inviting me and encouraging me to speak in Polish, but I'll stick with English.
I'm really happy to be here, and thank you so much for my best pen friend, Joanna, for invitation, and all the university which host us. And actually, it's a big pleasure to be and just to be involved in the project together with Polish and Ukrainian colleagues. So I'm really grateful for that. And today I will talk about mandatory mediation in family disputes, Lithuanian model and its outcomes. We already have that mandatory mediation in family disputes for more than 3 years. So it will be 4 years at the end of this year, like several weeks, and it will be 4 years. And of course, it was also quite good to evaluate what kind of results, what kind of outcomes it gave. So I will shortly talk about it. And having in mind that this conference is devoted for the child involvement into mediation, I will touch as well some aspects of child-inclusive mediation in Lithuania. Yes, I see it changes. And first thing I would like to say is about that mandatory mediation as a trend in family disputes in European Union. Together with my colleagues Julia Radanova and Indra Korsokeviene, we did we think that it was nice research on that, and we just saw that recently it can be concluded that in most European Union member countries, some kind of schemes of mandatory mediation already exist. So we have 6 countries with categorical mandatory mediation, and that means that in law provisions there is clearly stated that certain disputes should be mediated in mandatory form before filing the claim to the court. It's such kind of countries as Lithuania, Greece, Croatia, Malta, Estonia, Italy in some cases, because it's only what is related with family business disputes, but it's already six countries. And 18 countries apply discretional mandatory mediation. And Poland is one of them, actually. Of course, yesterday we had a nice discussion in the court that it doesn't work, as far as I heard, so effectively as it was planned to be, but still there is a right for the court to refer family dispute as well as other dispute to mandatory mediation. 4 apply quasi-mandatory mediation. At least 13 apply various incentives for fostering usage of mediation in family matters. And actually, only Denmark is the only country where there is no mandatoriness of mediation and there is no incentives to use mediation. Just nothing is done, but people still are doing that. So it's the only country where it comes, naturally maybe. And here is just a QR code if somebody is interested to read more about our research, so you can just check that our article. And here as well you can see, one moment. Yes, it's coming. The map of mandatory mediation in Europe. So it's like those colors shows the different models, and you can see that in some countries there is like a mixture. For example, in Lithuania we have mandatory categorical mediation, discretional, like court-referred mandatory mediation. We have various sanctions if people are not using mediation, and also we have a lot of incentives to use mediation. But still, to say frankly, before 2 weeks we were discussing in the international conference in Vilnius, mediation paradox still exists. Everybody knows that it is really good, that it's really effective, but still it's quite rare in practice. Okay, coming back to Lithuania, so I will reveal the main features of mandatory mediation. So what kind of disputes? So it's all family disputes, which may be solved by the settlement agreement. So we do not have any exceptions. And what is mandatory? It's mandatory to initiate mediation before filling up the claim. So a few minutes later I will show the scheme how everything works. And exceptions, it's only possibility to escape that mandatory mediation initiating if there is a record of domestic violence. But still the victim has right to not to use that mandatory mediation, but if it is the party of that conflict, he or she is mandated to mediate. And about funding, funded is by state. That also very specific for like Lithuania, and like normally in mandatory mediation schemes, we do not expect state to do such kind of presence awards for the parties to a dispute. But in Lithuania, it was the position from the government that if we do it mandatory, we need to provide opportunity to get it free of charge. So mediators are paid by the state, but it's some time restriction. So maximum 6 hours for today might be paid, and it's 1 hour for preparation, 4 hours for mediating, and 1 hour for formulating the results. And of course, parties are free to agree with a mediator to continue, but they're paying for the further hours from their own pocket. And we have a plan for changes in our legal regulation, and it will be a bit more funded. It will be 8 hours, maybe even next year. And there is like 2 possibilities. First possibility is for all residents, not even citizens, residents of Lithuania. They can apply for that mandatory family mediation for the state-guaranteed legal aid service. And normally they are like filling request, and that aid service is appointing mediator from the list. we have a register of the mediators, like Lithuanian list of the mediators, and for today it's about 700 people here involved, but not all of them are working with state-guaranteed legal aid service. It's like if you're willing, you can go into the contract relations. If not, so not. But the problem is, of course, the really low salary of the mediator. For today, it's 22 euros per hour state is paying, or it will be 25 from the 1st of January, but still it's not a game changer. Of course, market prices for the mediation services are much higher. Parties have another option. They can go just to certified mediator who is enrolled in the list of mediator, and they can pay from their pocket. So they can choose a mediator, they can choose, I don't know, nice location, they can choose a higher competence, and of course they are getting that procedure quickly. So that also is an option. And just now I can show, I hope that it is visible, I can show how it works. So disputants together may apply for the mandatory mediation services to the private mediator or the state-guaranteed legal aid service. And what happens next? Mediator, if like both parties are applying, they even can identify the concrete mediator from the list, and state-guaranteed legal aid service or private mediator who is chosen by the disputants, like starts the mandatory mediation process. In case of private mediators enters a contract with the parties, or parties are getting information about the appointment of state-funded mediator by the state agency. And like from this moment, it's like general mediation with a classical structure of the mediation and with generally well-known principles of the mediation. And in case of the settlement, parties are assisted in preparation of the settlement agreement, but mediators do not have obligation to draft the settlement agreement. Parties can go to the attorneys or to other lawyers, but if mediator is willing, he or she, of course, can help there, and normally it is charged in addition. And in case of unsuccessful mediation, maybe it's not good to say, because I really think that all mediations are successful because people are listening to each other, and that's good. But like in that formal way, unsuccessful mediation, mediators issue a document confirming fulfillment of the party's duty to mediate. And that document goes together with a claim for the court. And nowadays, judges who are in duty to decide to start trial or not, they're like searching for that document because mandatory mediation is obligatory to be proved before starting the procedure. If one of the party applies for the mandatory mediation, he or she also can go to private mediator or state-guaranteed legal aid service, and it's mostly happened that one party is initiating that mandatory mediation procedure. What we're doing next, private mediator or that state-guaranteed legal aid service, is sending a letter, contacting by phone, by other means, second party, and invites him or her to participate in mandatory mediation. And that's very interesting, that person has a right to choose whether he or she like to be involved or not. So it's like mandatory for claimant, but for the future respondent, it's not mandatory. He or she can like choose. And in case of positive answer, the same is happening, like mediation is going on. In case of silence or negative answer, mediator or state-guaranteed legal aid service as administrator informs the initiating party and provides a document proving that he or she fulfilled the duty to apply for mandatory mediation, and it also can go together with claim, and it justifies that requirement to mediate mandatory. So here I have some statistics how everything goes in Lithuania. So we already can investigate like 3-year period. In about 60% of cases in 2020, or a bit less in 2021 and 2022, the second party did not agree to mediate, and the process ended in initial stage. So what does it mean? That our mandatory mediation loses half of cases because of that freedom for the second party granted to choose or not to choose. Now we are working on the draft of the new law, and it was suggested by the academicians that mediator should be appointed earlier, like to escape that situation that state-guaranteed legal aid service, who is like really, that institution gets a lot of requests and do not have possibilities to have a personal contact with all the parties. So we decided to grant a right for the mediator just to be appointed and to contact second party, not like state institution writes a formal letter, but mediator is contacting that person, second party, and trying to present mediation as really beneficial for them. So we hope that the new law, the new regulation will come into the force in the September of 24, and that it will make some changes, because normally people are even scared when they're getting official letter that they should do something in mandatory form, and they are not informed about the mediation process and so on. Of course, we had a lot of campaigns for mandatory mediation and so on. There is like a lot of dissemination materials, but still, if you are not involved in a dispute, normally it doesn't matter for you. But if you are in trouble in dispute, that's the moment when you are searching for that information. So if I may, we also have very successful project in Lithuania Chamber of Mediators. We have a mediation info line. It's like phone number for everyone who is interested in mediating. They can just call and get answers to their questions. It is not allowed for our volunteers to suggest their own services. It's not about like advertising concrete mediators, but it's about disseminating mediation idea. And per one day, we're getting about 30 calls from people, and normally it is calls from those who are getting that official letter from state institutions saying you should do something in mandatory form, and they are like calling and asking. And there is also results, positive results, because state guaranteed legal aid service already informed us that that line helps to make that number of people agreeing to mediate higher, so that information helps. And the success rate of mandatory mediation is about 50%, as you see. Last year we have for 54%. So at first it was like when we just started at 38%, so it's growing a bit. So our mediators also are getting some more professionalism here, and we're doing quite nice. And it, like international statistics shows that to dream about 75% in mandatory mediation, it's impossible. So it's quite okay to have 50% success rate. Yes, and we already had an ex post evaluation of the mandatory mediation legal regulation, and in general, quantitative evaluation showed that the process of mandatory mediation is evaluated like 6,93 from 10 points. But it was, we were evaluating state-guaranteed mandatory mediation process, and having in mind that still a lot of people were not taking those benefits from mediation, we think that almost 7, it's good. Just because normally people do not like state-guaranteed services and say that it is like for free, so it's not very good quality and so on. So we were quite happy to get that number. And parties to a dispute were also invited to share their experiences, and they evaluated quite positive that mandatory mediation, even though it was unsuccessful in some cases. So opportunity for informal communication, they valued that very much. Assistant of the professional mediator, also they already acknowledged that it is helpful to have professional on board. Possibility to save money and time, of course, it's attractive, and acquiring new skills for better conflict resolution. So having mandatory mediation helps us to educate society as well, just setting the tone, how we're communicating in mediation. Of course, there are some shortcomings, relatively low competence of mediators. So some of them definitely did not show the high competence for their parties. Maybe that's normal because a lot of people are involved with different backgrounds, different trainings, and so on. Additional formality and obstacle seeking for court proceedings. You know, for those who are willing to litigate, mediation always will be an obstacle. And also lack of legal consultations from the side of the mediators. They were surprised that mediators are not providing legal consultations. So that's also education at the field where we should work a lot. Attorneys at law, we see attorneys at law as gatekeepers for our mediation ecosystem because it's really very important, their opinion. And they were quite happy about that mandatory mediation as well, because more time for the preparation for the court proceedings, also additional opportunities to settle. And some of them were saying, you know, when I'm trying to bring them to negotiation table, it's too difficult for me. They do not believe that it's beneficial. But when it's mandated to mediate, they are coming and they're doing that. And also wider spread of information about the benefits of settlements. Of course, there were some minuses as well listed, like the same competence of mediators, so we're thinking what to do, and actually there will be changes in our law in regard of competence development. We will have a higher number of hours every year required for the mediators. Also, some attorneys saw that it's additional formality, and they said that they are not clear what is the role of attorneys in the mediation. So that's for us mediators one more thing to do, just clearly find that role, because we know that support of attorneys for the development of mediation is very important. And judges were happy because more settlements were, and to confirm settlement is always easier than to investigate the case. So lower workload, so that already is visible in Lithuania. Even after failed mandatory mediation, parties to a dispute are more ready for the court proceedings. Judges are saying, you know, even in difficult cases, we quicker solve the dispute just because they come with clear position. They know what they should present. They know what questions will be dealt in the court. So that's easier, and that initial stage of civil procedure is like very quick, and they are ready to go. And of course, wider information spread. The minus from the perspective of the judge, the main was that some judges are lazy to conciliate because, you know, parties already tried mediation, so if mediator was not able to reconcile them, so maybe there is no sense to try and to have that initial hearings, to invite them in person and to work with them more in order to, through the court conciliation procedure, in order to find settlements. And certain number of cases when mandatory mediation was started only formally to get the access to justice at the court. Because, you know, if there is requirement, some people are thinking about it as a formality. So let's find the mediator who quickly will give me a document and I will be free to go to the court as some kind of heaven. But we know that mostly it's more hell than heaven. Yes, and what about child voice? So in finishing my presentation, so I would love to talk about it more. So Joanna and my Ukrainian colleagues inspired me to do the same survey in Lithuania. So what we saw that 98% of mediators, it was like a small group of practicing mediation. 45 mediators, family mediators who practice every day were questioned. So 98% of them think that during the mediation, best interest of the child should be implemented. So that's good. They understand that it is important, yes? 72% think that implementing the child interest is an exclusive obligation of parents, so they do not see their active role here. And 55% really thinks that child perspective in general is important. So like half of them, yes. Other part thinks that it depends on situation mostly. That in some situation child is important, in some not so important. So we have a lot of to do with education, I see. 80% mediators think that a mediator is obliged to remind the importance of the voice of the child. 87% think that involving of the child is possible only from certain age. So also we should educate more, and we should remember that rule that not the age but maturity, emotional development of child matters here, and actually there is no concrete age limit when we can ask child to tell his views. And 53% had certain experience of child-inclusive mediation, but only 11% of them are practicing it regularly. So it's quite rare in Lithuania. And my next slide also shows that representative survey of the mediators, what we were doing together with a team during ex-post evaluation, showed that it's really hearing a child in family mediation in Lithuania is especially rare practice. 3% of mediators do it always, 5% often, sometimes 49%, but you know that sometimes it's very, very like tricky answer, and 43% were honest, said never. So that's more, it seems to be a reality. And what conclusions what may be done? So mandatory mediation, definitely it's a new trend, and a lot of countries have a discussion to apply mediation in mandatory form, and a lot of countries already enjoy some schemes. And Lithuanian experience, I suppose, proves that mandatory mediation is an effective tool for quick raising mediation numbers and general awareness of mediation in society. And actually all stakeholders of the mediation ecosystem generally positively evaluate mandatory mediation and implementation practice of it. Still, mandatory mediation scheme not always pay necessary attention for the hearing of the child views. So with the help of mandatory mediation, at least 25% of family disputes in the Lithuania are settled by the mediated agreements, but approximately only 3% of mandatory mediation processes are child inclusive. So what is happening? Like we're trying to escape the litigation with all negative consequences of that, yes? But in litigation in Lithuania, it's normal practice to hear the child voice. And even some judges already denied the confirmation of the settlement agreements which were mediated just because it was not clear whether the child interests were taken into account and whether the child voice was heard during mediation or not. So I suppose it's like a new problem, new challenge, which we need to face, and we need to search for the means how to cope with that. So, and of course, those noted challenges may be overcome by developing family mediators' competences in the field of child view hearing and educating society in general about the importance of child voice. Because still Lithuanian society, Lithuanian lawyers and Lithuanian mediators, big part of them still thinks that it is harmful for their kid to be involved in parents' dispute, and they do not understand that, like, hearing the child views is very important for the emotional development of child, like being respected, being heard, being understood. And how can we imagine the future adults who are responsible, who are really taking care of others, if in their young age we do not care about their opinion? So I think that we have a lot of homeworks to do. Thank you.
Dziękujemy pani profesor i aż mnie świerzbi, żeby powiedzieć w kontekście tej mediacji obligatoryjnej, no mamy tak samo, ale niestety, jak państwo wiedzą, nasz ustawodawca wykazuje duży brak zdecydowania w tej kwestii.
Yes, as you know, the legislator well, sits on the fence, so to speak. So Janusz, well, let these words we heard from our colleague be an inspiration for us in the time to come, in the months to come.
To w takim razie ja
And
zapraszam,
I
zapraszam
pass
do
the
głosu
floor
panią
to
profesor
Ania.
Joannę Muchę. A to moment, na który
I
wszyscy czekaliśmy.
announce a
Pani
moment
profesor Joanna Mucha przedstawi
that we've all been waiting for impatiently. Professor Mucha will show to us the outcomes of her research on how Polish mediators see the inclusion of children in mediation proceedings, or the position of mediators on.
na Litwie wyniki badań.
It's part of what Ania just said. Being an organizer and a speaker at the same time is the worst possible role. I have taken the liberty to choose what's easiest for me. I'll try to be succinct, but also I know that you sometimes bet on whether Professor Mucha will keep to the time limit. Ania, please tell me, show me when my time is out. So once again, let me start with the following. Many of you remember that in 2021, together with Ania, we had a survey among Polish mediators. We had created survey questions themselves. We are fully aware it was not perfect. It was not bad either. Many of you took part in the survey. After its conclusion, we published the outcomes in a book. We came to a conclusion that it would be worthwhile to follow our research and to expand it a little bit. That's why we wanted to launch a second stage of the research study, and wanted to have on board our colleagues, eminent colleagues from Ukraine and Lithuania. The choice of the project partners was contingent on two criteria. Let me make a disclaimer. It was not a hypothesis we wanted to confirm in our research, because this was not the aim of our research. However, we did assume that because of geographical proximity and due to certain cultural, historical commonalities, as well as political links in the past, perhaps there is a similar approach among the mediators of our three countries to the perception of the role of the family and the position of the child within the family. The second criterion we adopted was the purely legal model of family mediation, which had by then been obligatory in Lithuania. In Poland, it was an option. Even though we did take efforts to make the mediation proceedings mandatory. At that point, we didn't have yet a law on mediation, which was adopted during our research conducted in Ukraine in November 2021, but we are certain that the inclusion of the provisions of the adoption of the mediation law in Ukraine did not affect the outcomes. What were some of the differences? Let me present you some of the bullet points.
Jakie były zatem kryteria doboru partnerów do projektu? Co nas, może najpierw, jakie były różnice pomiędzy nami? Króciutko w punktach, bo nie chcę się na
Back then, we hadn't had any surveys, any research conducted in our three countries concerning the inclusion of children in mediation proceedings. All our three countries are parties to the Convention on the Rights of the Child, and they are bound by its Article 12, which mandates the signatory states to allow the child to speak openly on matters related to the child.
Państwom członkowskim zapewnienie dziecku prawa do swobodnego wypowiadania
In none of the three countries there were provisions there were specific provisions on the inclusion of children in mediation proceedings. The differences, I will not expand on that, but the differences were related to the change to the different mediation model and whether the fact that the mediation is obligatory or mandatory or voluntary doesn't affect the perception of mediation proceedings. We assume that mediation, just like judicial proceedings, should put a premium on the best interest of the child. We moved in two directions. On the one hand, we wanted to check the practice, the mediation practice in our three countries, that is the scope of the phenomenon. Is inclusion of children in mediation proceedings frequent, or is it rare? Do we have any dependencies between the fact of inclusion of the child and the personal features of the mediator, and also the fact whether children are included in the proceedings directly or indirectly. The second area of research was related to the assessment of mediators as to the relevant subject. We were hoping to formulate certain more general conclusions. This is children's participation in mediation, Polish, Lithuanian, and Ukrainian perspective, comparative law research. This is the scope of research I spoke about. Let me introduce to you our team, which you know very well anyways. Let us move on to the facts and figures. In Poland, the study started in December 2020. A year later, the study began in Ukraine and Lithuania. You know very well that during the study, we were faced with very serious obstacles, which definitely extended the process. We collected responses from 102 mediators in Poland, 44 mediators in Lithuania, and 70 in Ukraine. Let me share with you some facts and figures on the respondents themselves. Women constitute the vast majority in all the three countries. It's about 75 to 25%. In Poland, it was 76% of the respondents were women. As for the education background of the mediators, half of the respondents were lawyers, 34% were psychologists or educators. Naturally, we also had a cross-section analysis of these indicators, and a vast majority of them are young mediators in Poland between the ages of 35 and 55. Some 9% are, either under 35 years of age or above 55 years of age. 19% of our respondents show more than 10 years of experience.
najdłuższy staż mediowania, czyli
Not
ponad
many of our respondents have more than 6 sessions per month.
duża liczba mediuje w
The
miarę
mediators of all
regularnie,
countries,
coraz
I'm going
więcej niż
to show this for Lithuania and Ukraine. Most of them indicated that they had taken part in training modalities of at least 40 hours. That's the indicator in Poland for at least.
Standardów naszej Rady 40 godzin taki wskaźnik przyjęłyśmy dla pozostałych państw.
30% of the mediators graduated from some post-degree courses in mediation.
Na ukończenie studiów podyplomowych jako swoje
In Ukraine, there were no indications of this sort.
W Polsce, podobnie na Litwie, na Ukrainie natomiast nie było takich sytuacji.
Now, what makes Lithuanian
Co różni mediatorów?
mediators different? 80% of them indicated that they were lawyers.
Wskazało na posiadanie wykształcenia tylko i wyłącznie prawnicze.
As for the age, here we have as many as 61% of mediators between the ages of 35 and 55.
Te grupy mediatorów młodszych i starszych, one też się
So
mniej
we
więcej
deal
równolegle
with a certain
rozkładają,
flattened
ale mamy jednak pewne
graph
różnice
here.
w stosunku do mediatorów polskich.
Only 4% of Lithuanian mediators
Mediacyjny ponad 10
had more than 10 years of experience.
ale może się to wiązać z tym, że mediacja na Litwie
But this
została
might have been because of the late introduction of mediation proceedings in Lithuania. 47% of Lithuanian mediators have regular meetings, 6 or more sessions per month, which I think might be due to the introduction of mandatory mediation in Lithuania. 84% of our respondents had completed training sessions. Now let's move on to Ukraine. Here the
ukraińskich kobiety dominują jeszcze bardziej. 64% prawnicy, czyli oni również dominują.
the group of mediators of middle age is about the same. Regular mediation is about 20%, just like in Poland.
Oscyluje według tego samego wyniku, co mediatorzy polscy.
One interesting slide I can share with you. We asked a question about the approach to mediation services, mediation as the core occupational activity. 16 mediators in Poland, 27 in Lithuania.
Mediatorów, którzy wskazali mediację jako podstawowe.
Let's move on to the outcomes of our research. We had a very high degree of responses on concerning the need to assure the representation of the perspective of the child in mediation proceedings. You can see, well, there are very insignificant derivations here, and the figures show that mediators do believe that the child's interest should be represented during the proceedings. We then asked the question, who, according to the mediators, should be in charge of advocating the child's perspective. Basically, the mediators put the burden on the parents. That's these are the bars on the left-hand side of the graph. Many respondents indicated the role of the mediator, the far right, but I find interesting something else. Mediators see room for the inclusion of third parties to mediation proceedings. These third parties might be responsible for showing the perspective of the child. And here the answers are basically the same as to the psychologist or educator or a lawyer who is tasked with being the child's advocate. Taking into account the child's point of view, this is not identified with the taking into consideration of the child's point of view in mediation proceedings. The first question, asked before, we had almost 100% when it comes to the need to ensure specific representation of the child's interest. However, here is another question, taking into account a child's point of view. These two are not equated by our mediators, and that's why we asked the question about the role of a mediator. The mediator is to be responsible for the introduction of the child's perspective into mediation proceedings. How is it going to be done? By quoting the wishes and expectations of the child in the wording of the settlement. You see here, recalling children's wishes and expectations revealed in mediation without forcing their inclusion in the settlement. Okay, let me focus on the interesting parts. We offered mediators examples of responses to the question about the factors that can assure most effectively the implementation of the principle of the child's best interest. And we had a number of replies to be chosen. Here we have the four most frequent replies offered by Polish and Lithuanian mediators. Let's have a look at Ukrainian mediators. The difference is that basically Ukrainian mediators are have a very high opinion on the obligation to inform a child about the content of the settlement. Now, the fifth factor is perhaps surprising. Here I show the factors that can assure most effectively the implementation of the principle of the child's best interest. Mandatory mediation. Is it something that can really ensure or guarantee the child's best interest in the proceedings? You see the figures for the three countries. Now, regulating children's participation in mediation, the vast majority of mediators would love to see more precise provisions concerning the child's participation in mediation, either by specific legal formulation or general recommendations. And now the matter of directly involving children in the mediation. Then we ask a question about an age limit below which a child should not be directly involved in mediation proceedings. Here you see that Polish mediators see that age is not as important. Time is of a concern for us, so I need to speed up. You see the age cohorts that the mediators indicated as the threshold under which children should not be involved. You have you see the years. Criteria for directly involving a child in mediation: emotional maturity, age first, emotional maturity, mental condition, finally consent and will are the four categories. A similar situation relates to parents and guardians, level of conflict, compliance with the rules of mediation. It was important for parents, dealing with emotions, the mental condition, readiness for exercise of parental authority, consent, and will. And in the case of mediators, we had two factors: qualifications to work with children and willingness to include children.
Mediatora, przygotowanie do pracy z dzieckiem, gotowość włączania dzieci do mediacji wśród mediatorów.
The logistical context, the experience of directly involving children in mediation.
Organizacyjny, doświadczenie bezpośrednie.
Jakub, help.
Panie Jakubie.
I had hoped. I have already exhausted
Miałam nadzieję, że pech mnie na dzisiaj opuści.
limits of bad luck.
Aha. Nie dotykać.
The first, the upper row,
Zawieszanie.
any contact, experience of directly involving children in mediation at any time, at the level of what?
Włączaniem dzieci do mediacji na poziomie 50%. Regularnie mediatorzy litewscy,
50%.
mediacja obligatoryjna, 11% ukraińscy i polscy.
Initiative to include children in mediation. I do apologize for not discussing it further. Here we have the tools used by mediators who directly involve children in mediation proceedings. We offered as many as 19 responses. Here you have 10, which were indicated most often. The 10 replies are almost identical for all the three nationalities.
Z jednym wyjątkiem w przypadku mediatorów litewskich, z dwoma wyjątkami na rzecz w przypadku mediatorów ukraińskich. Nie będę odczytywać.
There are two differences when it comes to Ukraine and one when it comes to
te różnice dla mediatorów
Lithuania. Directly involving children in mediation, active listening and expression of emotions by a mediator during the conversation. You see the figures, active listening and expression of emotions by a mediator during the conversation, informing a child about recording the conversation.
Pierwszych 10.
The first 5 replies are identical for all the three countries. The order may differ, but basically we are within the blue zone here, which indicates that we have arrived at a certain standard used by mediators who directly involve children in mediation proceedings. So once again, for Ukrainian mediators, active listening was ranked second. Here, let me skip some of the slides. Confidentiality, basically the same. No information could be shared without the child's consent. Lack of confidentiality on the far right. 4% for Lithuanian mediators, 2% for Polish ones. And now I'm really drawing to an end. Techniques for indirectly involving children in mediation proceedings. Here we used a number of possible replies. You have a review of all these replies, recalling the child's perspective directly, using symbolic tools, for example, reserving an empty chair at a table for a child, or asking parents to place a photo on the child on the table. The practice of inviting a person to a mediation as a child's advocate during parents' talks.
dziecka. Tak, przypominam Państwu, oczekiwania były dość wysokie, bo rzędu 40 kilku procent w każdym z naszych.
Do mediators do it?
Tutaj mamy
For Ukrainian mediators, affirmative answers are the most frequent. Homework for parents, including a conversation with the child on a topic that was previously agreed on.
Odpowiedzi twierdzące. Zadania to
Finally, techniques of indirectly involving a child in mediation, the conversation with the child in the participation or in the presence of a specialist, educator, or children's or child's psychologist.
Jest wskazana. Ania na mnie już spogląda złowrogo.
Conclusions. Well, they are far from complete and conclusive. I do hope you can read them.
Znacznie szersze. Mam nadzieję, że widać, mamy wielki ekran.
We also conducted cross analyses and drew an interesting, if a bit surprising conclusion.
Może nie. Mediatorzy, którzy wskazywali podwójne wykształcenie prawnicze i psychologiczno-pedagogiczne, ich stanowisko.
Those mediators who were lawyers by profession tended to apply more of a legal approach. The third dot, which is going to be discussed in depth by Anya in a moment, the mediators do see themselves as guarantors of the child's best interest. However, they also see that this may be in contravention of the principle of their neutrality.
Ta kropeczka czwarta, o czym już mówiłam, duża przestrzeń dla osób trzecich, w tym dla adwokata dziecka. Tutaj. Nie widać.
Some of the factors that are the most effective as guarantees of the child's interest in mediation is psychological and pedagogical support for the family in crisis, rather than the inclusion of legal aspects. And the final square, mediators see the unique status of the child involved in mediations. They do not support, however, the acquisition by the child of the status of a full-fledged party to mediation.
Tak, ani poprzez na przykład, tak jak napisałam, wprowadzenie obowiązku włączania dziecka, ani przez
These are my conclusions. The dominant conclusion is that the child is involved indirectly. You won the bet, right? If you bet it that I would exceed my time, my allotted time. Now we have Dr. Czernorecka. Do we have the connection? This is a speech that we've all been waiting for on the tenterhooks of attention. The principle of the inclusion of children in mediation proceedings, a person who knows everything about it. Doctor, the floor is yours.
Pani doktor. Pani doktor, czy
The microphone is off, doctor.
Tak, tak.
First and foremost, I wanted to thank you, Professor, for inviting me to participate in this conference, even though I need to make a certain provision, as the single person amongst you that has nothing to do with mediation. per se, as my experience is limited to offering experts' opinions in cases involving family and parental conflicts. But as part of this meeting, I should like to focus on matters related to a sort of discussion with the subject literature that I have been granted by Professor Mucha, as well as the literature I have read at my own leisure time, in particular the perspective of the child and in the context of executing parental prerogatives and in the context of conflicts. And I don't know if I'm sharing my screen. I guess I am. So, alright. Very well then. I don't really know why. Okay, now I do. This is the presentation flow I intended. And so I will begin with a few theses that it is hard to argue with, namely that the child should have the right to express his or her opinions and issues that affect them, and in mediations aimed at resolving a dispute between parents over the regulation of parental authority and contact with the child, depending on the case. The child is not the subject of decision-making, but the subject affected by a dispute. And last but not least, the agreement struck by parents will be accepted and recognized by the court if it takes into account the child's welfare. And from these theses follow the conclusions such as that the child should have the right to express his or her opinion in mediations, and taking into account the child's reasonable wishes in mediation will help resolve a parental dispute in a way that seeks to ensure the child's proper development. And I would like to verify if this is often the case and what preconditions are needed therefore. And the questions I want to consider are the following. What factors can affect the effectiveness and usefulness of mediation with the participation of the child? What are the possible forms of child participation in mediation? And should the necessary conditions for including the child in mediation be indicated? If so, what are they, and what sort of conditions should they be in order to help create conditions conducive to the child's development? And what are some psychological benefits of including the child in mediation? As you can see, I'm only referring to some of the most fundamental issues because I don't have the time to go into nuances. And so let's try to offer a psychological perspective first, starting with the factors that may affect the effectiveness and usefulness of mediation with the participation of the child. So the first factor that I'd like to address and point your attention to in particular, and one that is always considered in the subject literature, is the degree of psychological maturity of the child. And pay attention to the fact that I'm not referring to age, but psychological maturity, which includes both biological as well as psychological, individual and developmental conditions and factors. Naturally, this will all translate into some age groups, roughly, and I will take a step further even and say that this will include or refer to children who are older than the kindergarten age, and the median would be early elementary school, but I would oppose any rigid measurements in the form of legal principles or regulations, and the fact that Polish regulations mention the fact that the child should be mature in order to be considered as part of the mediation process is by and large reasonable. The next factor is the maturity of parents, who need to take into account the child's opinion and understand the need for parental cooperation. Furthermore, we need to consider the competences of the person who obtains and uses information provided by the child, be it a mediator or another party. And then we have to factor in the objective circumstances, including the agreement of different parties, the stage of separation and dispute between the parents, the stage of mediation, and the persons referring the family to mediation, as well as the consent of all parties, including the child. What are some of the possible forms of child participation in mediation? Starting with a direct form, this involves participation in mediation meetings. We can also speak of an indirect format, where different capacities can kick in, be it via the mediator, so a conversation or interview on terms similar to a court hearing, although again in here a mediator must bridge different roles and retain the principles of impartiality, and this often includes the potential collision of the mediator's role with other roles and the principles of impartiality, as I said, also the principles of neutrality and self-determination of the parties, as well as the representation of the child's interests, which all argue in favor of limiting the child's participation to the acquisition and transmission of information by the child between the parents. In terms of this indirect contact, it can take place through a proxy, through a child's attorney, which could involve a diagnostician, a counselor, or a consultant. So a diagnostician would have to be a psychologist, or a counselor, and consultant who should be a psychologist/pedagogue, definitely having some background in psychology. And so for diagnosis we would have to include a psychologist. The third form would be through the child's representative, so a subjective presentation of the child's point of view and their subjective interests as presented by Professor Mucha, without assessing those subjective interests. And we should also bear in mind the possibility of another type of proxy or attorney, which is parents of the child, who would talk to the child themselves and relay the information of the child's needs in a discussion as part of mediations. The precondition here would be that the child is the focal point of the parents' attention, and their proposal is consistent and accounts for psychological and legal factors. If this is not the case, then parental proxy cannot be taken into consideration. Other than these indirect measures, we have hybrid or mixed engagement at a different stage of mediation. So the child can participate partly directly, partly indirectly, and featuring different sorts of mediators. And if there is more than one child, then we could also opt for individual mediation featuring each child successively or collectively and in stages as pertains in the literature, starting with the mediation featuring all the siblings. Unless there are more than 3 siblings, then it will be more complex, and in such a scenario, that group should be broken down into smaller units before we move on to more complex matters and individual mediation. As to the conditions that should or must be met in order for inclusive mediation of the child to achieve its goals, that is, for it to lead to arrangements that create opportunities for the child to develop properly, including the benefits that may result from it, the essential conditions include, first and foremost, the consent of both parents and the child to be included in mediation. And I can't stress this enough because much of the literature glosses over this absolutely key factor. Then we have the potential willingness of parents to take into account the child's opinion, as well as the potential willingness of parents to cooperate in parental matters. Then the cognitive development of the child, which helps them express their opinion. And mind you that this is cognitive development as a necessary precondition, followed by the child's ability to understand that he or she is not responsible for reaching an agreement between his parents or her parents, and does not have a final say or does not exert an impact on the substance of such an agreement. Then we should also guarantee the child an understandable explanation of the inconsistency of the arrangements with their expectations and mitigate any stress or failure. If all of these necessary conditions are not met, we run a serious risk of secondary victimization of the child. And therefore, including the child in mediation would contradict the stated goal of taking into account the welfare of the child and ensuring the conditions for their proper development. So, in view of this, it should be considered that in such circumstances, the contradictions outweigh the potential benefits that could result from getting to know the child, or from learning the child's perspective. Let us now look at the direct forms of child's involvement, which are permissible only if the necessary conditions are met and the child is not involved in a coalition with either of its parents, and so it doesn't take sides. It has a strong sense of autonomy, and it is highly resilient to potential stress. And furthermore, its parents are oriented towards parental cooperation, and they're able to control their emotions while also staying open to discussing problems of care and upbringing adequate to the individual and development capabilities of the child. In mutual relations, we have to take care of a proper level of trust and proper relations between both parents and between each of the parents and the child that features in mediations. Now, as to the direct format, there are certain indisputable advantages that you can't guarantee or attain in other scenarios with respect it's a growing sensitivity to the children's needs and their well-being. In the case of children, this provides us, or mental maturity provides us with proper, ample opportunities to help grow the child's ability to solve conflicts in a socially acceptable way. And with respect to both parents and the child, we can directly exchange information and discuss possible solutions and shape and maintain attitudes, expectations, and commitments appropriate to the respective roles of parents and children as objective observers, along with an increased willingness to meet their mutual commitments and a sense of satisfaction reached alongside the agreement.
Wywiązywania się ze zobowiązań i satysfakcję z uzyskanego porozumienia. Więc jak widać, te korzyści są
And let me stress once more that the direct format tends to be difficult to implement, and you need to stay cautious of fulfilling all these preconditions before you proceed.
Forma pośrednia jest możliwa, jeśli są spełnione warunki.
In terms of mental maturity, these necessary conditions are fulfilled when the child manifests a degree of mental maturity that is sufficient to present their own opinion and satisfy the need to participate in shaping their own fate. We could use a mediator or a child's attorney or a child's proxy. And if the child struggles with transparently presenting its needs and expectations, then we should rely on the representative or a proxy that represents the child's reasonable interests. When the sense of autonomy is present, then we could rely on a mediator.
Tym pośrednikiem może być mediator, ale jeśli towarzyszy temu skłonność do manipulowania otoczeniem.
But if accompanied by a tendency to manipulate the environment, especially its parents, we would have to have a representative present as well. If there is a strong conflict of loyalties or a sense of coalition with one parent, then we should involve the child's attorney or proxy. And in terms of expressing opinions, if the child understands the consequences of the proposed solutions and is ready to implement them, the possible mediator will be the mediator per se or a child's attorney. And if the child's opinions are ad hoc and highly dependent on external circumstances, then we should involve the child's reasonable interests and his representative. When it comes to parental cooperation, if the parents are at least at the level of readiness towards agreement, then a mediator will suffice. For a more confrontational attitude, we would have to involve the representative of the child's reasonable interest and the child's attorney to a different degree and effect.
jak i pełnomocnik
And when it comes to
dziecka, tylko
openness to the child's
efektami.
opinion,
Pod względem
then we should
otwartości
have the mediator present,
jeśli występuje
at
mediator,
least to a
przynajmniej
basic
występuje
extent,
przynajmniej w podstawowym zakresie,
and if
to reprezentant rozsądny.
in other cases we should have the representative of the child's reasonable interest.
Dziecka.
And then there are other conditions for the indirect form as well.
Oprócz narzuconych
Other than the general provisions of law, these individuals should meet the following criteria. The mediator, in addition to those competences imposed by the law, the mediator should be aware of the functioning of the family and in conditions of separation and divorce. They should further be aware of the child's development and the legal issues in the areas in question. As to the child's attorney, they should have the knowledge, the legal knowledge in the subject area. They should be able to communicate with children, and they should be aware of the representative of the reasonable interest of the child should be able to provide a psychological diagnosis of the child, recognize symptoms of maladaptation and the conditions of crisis associated with the separation of parents and assessment of his or her educational situation. They should be clinically experienced and able to distinguish permanent deficits from disorders that are adaptive in nature, and they should have the basic knowledge of legislation and the field in question, analogous to the competence of an expert in parenting matters.
Jak te, które się przedstawia biegłym w standardach opiniowania psychologicznego.
Now, when it comes to the benefits of the indirect format, as a result of the mediator and the child's representative's actions, the possible benefits may include a chance to work out an agreement together, a satisfaction and willingness of the parents and the child to implement an agreement, increasing sensitivity of the parents to the needs of their child, as well as the skills of conflict resolution and their building and an actual resolution of a conflict in a socially acceptable manner, an opportunity for direct involvement of the child in the subsequent stages of the process, along with the support of the child by the specialist, and then finally, as a result of the activities of the child's attorney, we should get to know the child's perspective, represent the child's expectations, and from the perspective of the direct recipient of the child's communications, namely mediations versus court proceedings, we will have to acknowledge a chance to learn the child's perspective at an earlier stage of the proceedings and to establish an understanding with the parents. So two indubitable advantages. And now onto the conclusions, which I'd like to begin with stating a concerning readiness of lawyers and oftentimes also other professionals working with the judiciary, the willingness to deal with the child's right to have their opinion heard as an obligation in this regard, and the attendant danger of victimization of the child in the name of their interests. Undoubtedly,
No, niewątpliwie cenną wartością włączania dziecka w mediację są szanse przedstawienia przez nie swojej perspektywy i poznania swojej sytuacji wychowawczej. W tym
one added value of involving the child in mediation includes the chance for them to present their perspective and to help others learn about their situation at the pre-court stage. The lower gravitas of the relation with a mediator when compared with a judge, and If I may, I would also propose a hybrid model which would use 3 among the discussed forms of contact with the child as the most useful model. Namely, these 3 forms would include the mediator as a person to obtain information and to elicit it from the child, a representative of the child's reasonable interests and wishes for particularly difficult cases, as well as the child's attorney during or after mediation if the parents failed to give consent to include the child in the mediation or do not want to consider the child's reasonable wishes and interests. The decision in this regard would be made by the court on the basis of an assessment of the content of the provision without the need for the mediator to denounce the parents. Further, there is an urgent need for training of relevant personnel, and I don't share the optimism of some of the previous speakers today regarding the adequate training of specialist personnel with regard to including the child in mediation and court proceedings. I think that all of this hinges upon the subject matter which will involve the child, and this calls for more diligent preparation. And at the current state of the system and its development, we should probably include mediators as potential educators, along with other experts recommended or referred to by the Court of Law. I should also encourage you to promote mediation in the mass media, because the questionnaires we've conducted clearly point to the undeniable advantages of mediation as a means and a directly opposite ignorance of society with regard to those benefits. And we should also consider the information regarding the child's perspective in these proceedings, which depends on parenting competences, which are not always satisfactory at a general level, as well as the crisis separation, which further reduces these competences. We should also cater to the needs of the child, knowing full well that some parents will be inherently unable to remain sensitive to these needs and to meet them. And we should strive to not only task the court with reviewing these issues, but to establish them as early as possible at the mediation stage. The limits of the mediator's intervention are to point out to the parents the aspects of the agreement that are contrary to the child's welfare and to propose solutions to sensitize the parents to these perceptions of the child's perspective. And last but not least, in the case of consensual and at the same time evident violation of the child's welfare in the context of ending a dispute between parents, the mediation should be terminated due to the establishment of psychological violence against the child. And thus I have reached the end of my presentation. And hopefully I will be able to address some of the possible questions during a Q&A at the end of this panel. Thank you very much.
Pani doktor, serdecznie dziękuję. Na pewno wrócimy do tych
Thank you so much, Doctor. We are certain to revisit these issues. And now I have the indisputable honor of having been read by you, Doctor. I'm really thankful for being part of this conference. And now the time has come to hear our last panelist. Last but not least, we will hear Dr. Anna Cybulko, the member of our team on the participation of children. Well, there will be consequences of what I did with you, namely showing you that the time is short. I'll try to be brief. I'm really honored to be speaking to you and referring to an excellent project led by Professor Joanna Mucha. I will try to focus on the role of the mediator. How many of you are practicing mediators? By a show of hands. Right, so we are all in the same boat and in the same shoes. I believe we all need to tackle the same challenges. Which of you have been involved in family mediation proceedings? We all know that the role of the mediator in mediation proceedings related to children is very unique. This is the category we've all been speaking about throughout the day. I don't need to expand on the topic. The best interest of the child is of paramount importance when it comes to conflict resolution or in judicial proceedings. One of the biggest challenges for the mediator is, on the one hand, to take into account the best interest of the child, and on the other hand, we need to take care of our mentality, neutrality of the mediator, and to bridge the two may be a challenge. Now, how is this taken care of in the provisions, in the legal provisions, in the legal framework, and in the practice? How can this discrepancy between the role of the mediator be resolved? We have some legal regulations, we have some sectoral regulations, as well as commonsensical practice. The solutions can be many and varied. Before I show you how this is solved in Poland, I'll try also to have a look at the practice, not only the legal solutions, but also the practice in Poland. I would like to show to you some of the possibilities of a practical solution of the problem. I'd like to mention two dimensions which are of importance. That is, what is seen as one of the main objectives of the role of the mediator, the protection of the good of the child, or the child's position. And here, let me give you a quotation. Mediators dealing with the custody and contact cases tend to be on a continuum, at one end of which there are those who believe that the mediator's role is merely to neutrally facilitate negotiations between two parents, and at the other end are those who believe that the mediator's role is to be a forceful and consistent advocate for the child's cause. And we have another quote which shows that, and here let me read you out the quote, at one extreme there will be approaches that assume that the child is the party to the mediation, which is generally accompanied by a belief in the need to include the child in the mediation proceedings wherever possible, and at the other end there will be beliefs that only the parents are parties to the proceedings and the child is at most and best a stakeholder in the proceedings. So here we can have 4 different categories of approaches to the role of the mediator. Importantly, what are some of the values that underpin these positions? The focus on neutrality first. Let me tell you that the mediator, on the one hand, should stay impartial and should and not discourage the parents from the process. The very conclusion of the agreement, the very entry into a settlement is a step towards meeting the needs of the child, in particular the sense of security and predictability, and it's the best path to satisfying a child's rights and needs is to provide support to the child's parents. However, we have an intermediate approach, and we also have the approach which concerns the focusing on the welfare of the child. The mediator has a moral obligation to take care of the hidden participant in the mediation, which is a child who is dependent on the parents. Mediation should be transformed in the spirit of a more effective resolution of the child's problems in parental separations. And impartiality of the mediator should not be seen as a priority and should be seen flexibly. But actually the solutions being introduced are resolved in practice. There are always intermediate approaches to the topic, and here we have an option which assumes that including a third party to the mediation proceedings, i.e. a person representing the interests of the child, such as a guardian, advocate, or a child's consultant, is the best solution. It's a certain pool of solutions. Now, how is this solved internationally? Let me start with Australia, then the US, followed by the Nordic countries. Australia is an interesting area because mediation there is reconstructed, and it importantly mediation with the participation of children is mandatory, and in most countries where the mediator should be the child's advocate, are those countries with mandatory family mediation, so it may change the perspective. In Australia, the mediator has been empowered, assigned by statute, the role of a person responsible for including the interests of the child in the mediation settlement. This is what we just heard a moment ago from Dr. Czagrecka. There are 2 paths, two practical paths. This is child-inclusive mediation and child-focused mediation. In the first case, the mediator's role is to verify the possibility of directly including children in the mediation by contacting a professional consultant, an external person. The mediator asks the parents
do udziału w
to
mediacji
take part
i
in the
wprowadza
proceedings
jakby postać tego
and
konsultanta, jakiś
introduces
spotyka się
a professional
odrębnie z
consultant. The
konsultantem,
child
a
meets
następnie w
with a
miarę możliwości i
consultant,
zgody dziecka rodzice
and
uzyskują
then
profesjonalną informację na temat
the
sytuacji
parents
potrzeb dziecka, którą mogą
receive
wykorzystywać
from the
w
professional information on the child's situation and needs.
tej formuły
This is rather close to the intermediary formula I spoke of a moment ago.
a dziecko jest traktowane jako
And
ale w jakiejś mierze to być może
so
łączy,
the child is
rozwiązuje te tematy
not
mediatory.
in the center of
Zupełnie
attention.
inaczej wygląda mediacja
In the
skoncentrowana
previous
na dziecku.
approach,
Tutaj to
child-centered
mediator ma
mediation.
proaktywną
Here,
i
it is
ma
the mediator
unaocznić,
who
co
works
potrzeby
proactively
dzieci,
to
a
make parents
interwencje
aware
mediatora
of the
mają
children's
być
needs.
edukacyjne
The
i
interventions made by the
terapeutyczne.
mediator have an educational and therapeutic
Tutaj
dimension
zupełnie traci
for each
mediator
parent. The
neutralności.
mediator, stepping into the role of
Oczywiście
an
tutaj to
advocate
wykształcenie
of the
musi
child's
być
interest,
bardzo, bardzo
loses
szczególne.
the
Także
attribute
w
of
Australii idą różnymi
neutrality.
ścieżkami, ale to, co jest
So
ważne,
what's important
to to, że ta
for both
mediacja
these
ma służyć
approaches
interesom dziecka i
is
rodziny.
that mediation
Jakby te
should
podstawowe
prioritize
zasady
the child's
mediacji
best
gdzieś
interest.
pozostają na dalekim drugim planie. Co ciekawe, w Stanach Zjednoczonych, w których
Interestingly, in
na
the
poziomie
US,
ogólnym regulacji branżowych mediacja i
were
neutralność mediatora jest uważana za istotną
at the
wartość
sectoral level,
stron i to jest jakby
mandatory
podkreślone w
mediation
rozwiązaniach, które wprowadzili.
is seen as
I na przykład,
supreme
mimo że
value,
branżowe regulacje mówią, mediator powinien być neutralny, bezstronny,
even
dbać o
though sectoral
stron,
sectoral
wprowadzać tylko perspektywę
solutions say
dziecka
that
do
the
mediacji.
mediator should
To
be
stan Kalifornia na
should
przykład
be
wprowadził sobie na poziomie
impartial. The state of California
wymóg, że mediator ma obowiązek oceny
introduced a
potrzeb
state
interesów
law
dziecka lub dzieci, które
which
jest
mandates the
do
mediator
przeprowadzenia wywiadu z dzieckiem
to assess the needs and interests of the child or children involved in the dispute, and the mediator is authorized to interview the child or children whenever he or she deems it just or necessary. So actually, we don't deal with the parental approval. We don't deal with any consent on the part of the parents. The mediator has a different status in the whole process, and naturally we also have mandatory mediation in divorce cases involving children, and we also have
przez cały czas trwania mediacji jego obowiązkiem jest dokonywanie oceny potrzeb i
an
sytuacji
empowerment
dzieci, oczywiście
model
dzielenie się tym ze stronami.
where
Bardzo mediacyjne.
the mediator shares the needs of the children
I
with
kluczowym momentem mediacji jest podjęcie
with the
przez
parents.
mediatora decyzji o
And the
tym, czy
key
bezpośrednio
moment
włączyć
of
dziecko do mediacji.
mediation
Znowu,
is whether the child should be
kluczowe w tym modelu jest to,
should be
żeby
directly
dzieci
involved in the
uzyskały
mediation
informacje, które
proceedings. And
pozwolą
what's
im
key here
zrozumieć bieżącą
is
sytuację swoją i
the
rodziców
information
oraz poznać
forwarded to the child,
Znowu szczytny
which
cel,
will help
znowu
the
wracając
child
do tej
get to
prezentacji,
know
była o tym mowa,
the
że to jest decyzja ważna.
immediate his or her immediate status and the situation of the family. So you may say that the underlying objective is very noble, but whether it's doable is another thing. In Indiana, the mediator acts as a proxy for the child, or possibly the entire family. All members of the family community living under the same roof are invited to the mediation meetings. Foster siblings, aunts, grandparents, and so on and so forth. And the evaluative mediator is a mental health expert who forms an opinion on the best interest of the child. Why do I speak about variational mediation? If the parties settle a dispute, they send the settlement to court. However, if they fail to resolve a dispute, the mediator sends an expert opinion on what the best interest of the child is. And again, this is a big if. Well, this is a big question mark we should put here.
Północni. Prawie sąsiedzi, dziękuję. Właśnie szukałam tego słowa. Norwegia i Finlandia jako nasi prawie sąsiedzi.
Another approach is adopted in the Nordic countries.
Bo można powiedzieć, świetnie, zadbajmy o to na poziomie przepisów.
The situation is more difficult because on the one hand we want to, whether in Finland or in Norway, to regulate by law that mediation is based on an impartial and neutral support of the parties in reaching a mutually satisfactory agreement. So we do care about impartiality, which is great. However, the mediator is in charge of taking into account the best interest of the child in the proceedings and its and their effects. Here, the child is seen as a stakeholder, not as the acting or participating subject, but as a stakeholder, which changes the perspective. Mediation in court is conducted in pairs, consisting of a district court judge, assisted by an expert mediator who is a social worker, psychiatrist, or psychologist specializing in divorce or developmental psychology.
Kto jest za tym, że bardzo?
Who thinks that this affects our impartiality? Let's move on to Norway in a moment. In practice, the way in which the mediator's role is performed largely depends on the mediation style individually adopted by a given professional. Well, let's move on to Norway. Here, mediation in divorce cases is mandatory. The mediator is an expert on family issues, and mediation in family cases is conducted by a judge together with a mediator, an expert in family matters. Mediation is embedded in the preparatory part of the proceedings. The judge, acting as mediator, can later issue a ruling on the case. The mediator should focus on the welfare of the child and make the parents aware that the child also has the right to be heard. According to the principle, experts can perform three functions in family proceedings: mediator, mentor, or diagnostician. Whether mediators mediating the case will be appointed for diagnostic activities depends on the will of the court. Some do it, and the willingness of the mediator. Some of the mediators agree, others, quite to the contrary, feel it very bad. So again, the dilemmas are part and parcel of the binding provisions, and the mediators themselves need to solve the problem. Now, what about Poland? We do know about this. The role of the family mediator in legal terms. We see that the Code of Civil Procedure makes specific recommendations and makes the role of the mediator very unique. However, there are no precise provisions on that. We have certain regulations, like the recommendation number R98-1 of the Committee of the Ministers of the Council of Europe to Member States on family mediation and explanatory memorandum. We have certain standards for the conduct of mediation and the conduct of the mediator of the Social Council for ADR. We have standards for the conduct of family mediation of the Association of Family Mediators. I believe, again, we need more precise regulations. We have 4 main points in SMR standards for conducting family mediation. A family mediator helps the parents determine how best to look after the interest of their minor children. So again, the child is the stakeholder, and evidently we do take into consideration the basic principles of mediation, definitely impartiality, and the voluntary aspect of mediation. Children are not seen as the priority. Children are important as are the parents. The mediator enables the parties to create a parenting plan that provides a sense of security and stability for both children and parents, and importantly, and this calls for specific psychological competences. The mediator's obligation is to ensure that the child does not feel burdened by responsibility for the course or outcome of the mediation. In other words, we deal with a solution of a dilemma more towards mediation. The last 2 slides about the outcomes of our research and what we do in practice. In practice, on the basis of our research, we can say that the child was seen by our respondents as a stakeholder rather than a participant to the proceedings in equal rights to the those of the parents. In practice, Professor Mucha said, in practice, this means that nearly 60% of people identified parents as the entity responsible for representing the child's interest in mediation. 41 pointed to the mediator in the context. We would need a further study on how our respondents understood this.
Z badań wynika, że uczestnicy bardzo wyraźnie widzą dylematy, bo z jednej strony
our respondents are aware of the dilemmas, as we showed on the slides earlier. On the one hand, the mediator should be the guarantor of the child's best interest, but while 33% agreed to some extent, 60% completely agreed with this assumption. Again, we don't have a clear picture here. Let's, however, say that mediators are aware of the risk factors that may hinder their role as guarantors of the child's best interest. Here, respondents indicated there is a risk of conflict with the ethical principles inherent in the mediator's role, particularly neutrality and impartiality, difficulties arising from the lack of the necessary psychological competence of the mediator, incompatibility of such an approach with expectations on the part of the mediation participants, and difficulties arising from the lack of clear regulations in this area. So once again, in summary, the scope of the mediator's tasks includes assisting the parents in taking care of the child's interest, but without a very clear defined framework of neutrality and not abandoning the role of an impartial specialist supporting the parties' communication. Thank you so much. Thank you so much, Ania. Without further ado, let us have a lunch break now, and join us after the break. We have some practical aspects to be discussed, and then maybe you would like to share your impressions. Thank you.
Okay, ladies and gentlemen. Time to reconvene for our final panel. Yes, do take your seats, gentlemen. And we shall start with Janusz Kazimierczak, President of the Association of Family Mediators. In full accordance with the program, he's next on our agenda, and he will speak on child welfare on the banners of conflicted parents participating in mediation.
Tu się różne rzeczy dzieją przy tym prezydialnym. To dziękuję pani
profesor. Professor, for your kind introduction.
Pan ogarnął film, ale to nie mój, to kogoś innego. Jakby moją prezentację poprosił o duży ekran.
Now proceed to my presentation.
Chcę państwa zabrać dzisiaj
take you on a
w
journey,
związku z tym, że jestem
since
filozofem,
I'm a philosopher by education, through the land of postmodernism and social constructivism and narrative mediation. This journey will be taken in the context of child welfare, which is often put on the banners of conflicted parents when entering mediation, and it's all about justice for all and willing to be heard and being equal in the thick of it. But as I keep track of different parental groups on Facebook, I can see such posts as this one. Please recommend the trusted lawyer I've been battling for.
Od roku nie mam żadnego kontaktu z córką. Nie?
custody over my child for several years, and to no avail, I need to lawyer up. So we encounter parents who are before us mediators for the welfare of their child, at least technically, and they want to test different solutions, and we as mediators do have our own
Ale być może pytamy się, czy oni rozumieją je jednakowo.
preconceptions as to their understanding of the notion of the child's welfare, which has been accompanying us throughout this conference today. And I think that postmodernism and social constructivism are capable of providing some answers as to how these constructs emerge, and the fact that they're not objective or tangible, and that there is no single definition that would fully encompass the child's welfare. I want to point your attention to the situation in which we are approached by the child's parents, and the child is absent from the table, not even indirectly. And each of the parents argues that they're all about the child's welfare, but they also keep using this militaristic vocabulary. I battle for, or I struggle to secure, I don't know, Christmas or Easter with my child, visitations, that's my favorite word, and the child should probably have one home as they see it, and they should only visit the other, because otherwise they will be confused. Another thing is that they reportedly try to protect the child from violence and abuse. Obviously perpetrated by the other party, as per their accounts. Then they want to respect the child's refusal to see the other parent. The child is, after all, 8 or 9, and they're fully conscious of their own needs, and if they don't want to see the other parent, then why not leave it up to them, to the child's decision, that is. It's the kind of language we encounter in our daily profession. This is the kind of banners that they wave in our face, pleading for the best interest of the child, even though they have their own interests at stake. And this is where a discussion starts, with different proxies involved around the table about different verdicts, different decisions by the local judiciary. Our court, they say, will not bump our alimony above 800 zlotys per month, because that's the rigid standard that they never diverge from here in this district, and so on. And so you can see that different narratives unfold that are anchored in postmodernism and social constructivism, which will be the two notions I shall address in a moment. And why don't we now take a closer look at Winslade and Monk's practicing narrative mediation arguments used by parents, and based on Professor de Barbaro, a Polish therapist and psychologist, I compiled these arguments and invoke his examples. De Barbaro argues that similar arguments and conclusions of a constructivist nature date back all the way to the turn of the century, that's the turn of the 19th and 20th century. And in this context, Winslade and Monk argue that context is of paramount importance because it exerts an impact on both parties. And it requires cooperation of both parents rather than taking guilt trips against each other. For instance, if a 7-year-old states that he or she wants to commit suicide because they don't want to live in the living hell that their parents prepared for them, you can weaponize it, but you can also externalize it, and you can use it as part of your narrative, as a dark cloud that hovers over your family.
być może wypowiedziany tylko do jednego z
And it
rodziców,
can be weaponized
którego
by
akurat
one or both
otworzyło
parents
i poczuło się na tyle bezpiecznie, żeby powiedzieć,
who have heard
"Mamo,
it
tato,
straight from the horse's or the child's mouth.
życiem". To, co ważne jeszcze, to w
What
tej
is also
koncepcji
important in this narrative
staramy
concept,
się
we
wsłuchać
try
tych opowieści,
to
strony
tune in
używają
to
różnych
those stories and notions invoked
czasem
by
nimi bardzo
parents
mocno też grają,
who,
czasem
as I
bardzo
said,
mocno ich trzymają.
weaponize them
W
and
drodze medytacji akurat narratywnej
stick to their
podpowiadają,
guns
żeby
throughout the
wykorzystywać
process,
pytania badawcze i takie pytania,
nonetheless
pomogą nam
providing us
tworzyć
with
wyjątki
interesting case
i tworzyć
studies
zupełnie nową
and
opowieść o tej historii,
narrative
która się
patterns
przydarzyła.
about their individual stories,
przestrzeń, która
and
zabiera
this
sporo
is
czasu,
a
ale
space that
robimy to
takes
często
up
w
a
mediacji
lot of time and energy in
rodzinnej
family
i
mediation,
zadajemy takie pytania nawet
and
klaryfikujące,
that
to znaczy,
requires
co pan rozumie pod
follow-up
pojęciem
questions
X?
such as
I my
what do you
nagle
understand
zaczynamy
as or what do you
rozumieć,
mean
co tam się
by
dzieje, na ile to jest
Z.
istotne, na ile to jest coś, co
That's
jest rzeczywiście
crucial,
na przykład bardzo ciężkie
albeit
materie. Nie wiem, jeśli ktoś
difficult
mówi,
and
on jest
challenging
przemocowy,
in terms of matter.
ona jest przemocowa,
If
ona
somebody
stosuje
accuses the other party of
przemoc,
being an
zawsze
abuser,
zadaję pytanie,
I
czy jest
always
coś już, jakiś bieg
ask
nadany?
whether they've done something about
Niebieska karta,
that
co najmniej,
formally,
postępowanie
a so-called blue card, reporting it to the police and so on, whether they've taken some legal steps. And no is the most common answer.
Co jest bardzo ciężkie, bardzo brzmi poważnie.
So even though there is a great gravity attached to these accusations, not much is done by most parents, even though it seems implausible to me that
że w sumie to ja mam zgodę.
so many parents would be completely oblivious or ignorant of the fact that their child is abused, but they don't do anything about it.
I to, co jeszcze Winslade i Monk jakby podpowiadają, to to, że
What we can also
historia ma swoje źródło w sytuacji
draw from Winslade and Monk is that the
the
family context is also grounded in professional context, religious context, social context, even age-related context. So age plays an important role along with the other fields that shape up the balance or imbalance within a family. And this is where we kick in as mediators. Obviously, there are a certain context in which you should not engage in mediation when the imbalance of power is too great. But the imminent follow-up question is how do we measure it? And where does the boundary lie?
Żeby powiedzieć, że jest taka
For example, with economic inequality.
I teraz ta mediacja narratywna, ona wyrasta
So this narrative mediation that I want to talk about rose out of postmodernism, Jacques Derrida and Michel Foucault mostly, who posed some concepts that are useful for us as practicing mediators. These two sources are first and foremost deconstruction, in particular with respect to a certain description or notions, it's deconstruction or their deconstruction through clarification, seeking exceptions and emphasizing general quantifiers. So you never you always let the child go to school without properly dressing her or him beforehand. This is something that usually covers something that lies within, that is more deep-seated. Whenever I mediate in Toruń, I seem to run into high conflict couples that even prosecutors and judges fail to cope with, and they end up in my practice. So tensions are running high, and there is a great deal of polarization, a great deal of certainty for each party about their righteousness. And whenever they sit at the same table and we have a conversation, the first question is whether they admit multi-narrative situation, because according to postmodernist philosophers, there is no single truth. And if we were to quantify and measure how we perceive the color of these seats, for example, in this room, we would each locate it differently based on our preconceptions or preconditions such as astigmatic eyesight and other ailments or predilections. And the question that arises is, what if your description of the situation is not the sole binding one, if there is a counter statement of equal weight that comes from the other parent or the child. And so adopting or recognizing this possibility of different truths at the same time, and acknowledging the fact that this affects our child, and we have to vary our differences in order to work out the situation, because otherwise we will have, if we don't bury those differences, we will likely bury our relationship with the child. And that's something that Professor De Barbaro often addresses when thinking of a certain circularity in our work with divorcing or separated parents. And the preconception that it's better for us not to know the full truth in many aspects thereof, or not to seek for it, and that's why many mediators don't dig deep inside the details. Whether or not a child suffers from allergies or not, you have to establish those details. Even though many mediators choose not to read into the files before they sit at the table, in order to admit that multilateral idea of truth. So perhaps it's better to not know everything, but be inquisitive and ask about details. And then we've got social constructivism, and the social construct of dialogue, or Alfred Korzywski, and his idea of the map, which is not a territory according to him, or Olga Tokarczuk's statement from Kobieta nie istnieje, where she stated that reality is born in a relationship. It's a bit of a tent that is spread amidst notions, ideas, preconceptions. And so it's not the reality that influences how we speak and what we speak, but it's what we speak and how we speak it that shapes up reality according to constructivism. And I would wager a lot on you being able to feel the difference between the people who approached you before they drafted and filed a lawsuit and after they have engaged in and been bruised by mutual conflict. And this is the very point at which language structures their conflict in a militaristic fashion and pits them against each other in a very harsh fashion. Greta Nordheller, sorry for that, that's my timer, I guess. I'm 5 minutes away from the end of my presentation. Anyway, by changing your language, you can change the nature of the conflict, states one of the constructivist philosophers, as if to encourage us that if we help people use different phrases to vocalize their argumentation, it will change the gravity of their conflict and the nature of their communication. For example, by merely eliminating slurs and offenses, you can reach more than you can expect, and you can indeed encourage and sway the other party to communicate with you and to reach some sort of consensus. And last but not least, some mediation tips for us. And peeking behind the curtain. If you use reframing as a purification of language, you can indeed achieve a lot. And it's not about admonishing the parties not to use certain offensive terms or language which you prohibit from your office, but by encouraging them to use softer language in order to extract what's key in your meeting. The other issue is to deconstruct concepts that are heavy and that on the other hand are incongruent with the character of the charge. So you offend the other party even though the offense itself that they have committed according to you was not heavy enough in order to invite such language. One more issue is to strike a mediation contract instead of a monologue. I know that many mediators are in favor of monologues, but I think that this methodology is passé. It's not it doesn't fit the situation, and I think it's more conducive for mutual agreement to draft a contract between ourselves and both parties, and to contract all parties to stick to a certain mode of operation. And last but not least, we should bid farewell to Article 917 of the Polish Civil Code, which fails to apply in mediations involving parental authority, custody, variants thereof, and so on. It reduces the nature of the problem, which it shouldn't. And finally, I would like to show you what happens with divorces at the district courts in Poland in terms of entrustment of parental authority over children. And I always pity that the Ministry of Justice does not bother to be as diligent with custody and shared custody in particular, and the execution thereof. So the trend to entrust both the father and the mother with parental authority has been on the rise, with the exception of 2020-2021, where certain changes were made in the Polish legislation. Then, in terms of entrustment of parental authority solely to the father upon divorce, you can see that the tendency is declining, but in general, the number of instances in which it was the father who was entrusted with parental authority was rather low itself in the first place. And the same concerns full entrustment of parental authority solely to the mother. The tendency is to recognize the authority of both parents and to let them both execute it, which well, gives us mediators all the more work, because they will approach us to seek the best possible solutions with the child's best interest in mind. And speaking of that best interest and the well-being of welfare of the child is troublesome itself, because a constructivist would say that the welfare of your child will be born out of your narratives, out of your descriptions, out of your common notions, and what you see as best for your child. So let's try to iron out this new narrative that you'll be able to agree on, both of you. And I think that the Court of Law, when passing a verdict, does not really adhere to this principle and does not really meet the child's welfare. Now, a new mindset, as we said, is on the rise, in which the child's attorney, representative, as they are referred to in Polish legislation. The question is whether we should consider them another stakeholder at the mediation table and another narrative that they will chip into that table. So, other than the child, the parent, the second parent, and the mediator, and other parties. And I guess that it is by maybe escaping negotiations and agreement that we can coin these new solutions. And I cannot encourage you enough to read Bogdan de Barbarov's book on this subject, which is very substantial and carries water for all of us as mediators, especially when we prepare for a conversation with the client or with respect to the process of internalization or circularity, or how do you operate with metaphors, not only in couples therapy but also in mediations. So yeah, that's pretty much it. Thank you.
Bardzo dziękujemy, panie Januszu, i ponieważ siedzimy tu już długo, to może przejdę od razu do zapowiedzenia kolejnego wystąpienia. Tym razem mamy duet mieszany. Nie ta pani Agnieszka Tulin-Karp.
And now we have a mixed duo of our next speakers, Agnieszka Tulin-Karp, Łukasz Kwiatkowski, whom you know very well from the Pelican Association. I'm looking forward to your presentation.
Mogę spróbować bez mikrofonu? Jestem przygłucha, więc co do zasady mówię zawsze głośno. Jasne. On jest włączony? Tak. To znaczy ja wcale nie mam pewności, czy Stowarzyszenie Pelikan jest...
The Pelican Association is that well known, so we split our obligations in the following manner. I'll say a few words by way of introduction. He'll have the presentation.
Bo to był jakby główny powód zaproszenia nas dzisiaj tutaj do Poznania. Dziękujemy. To jest takie trójmiejskie podwórko, ten nasz projekt, który przez 2 lata prowadziliśmy. Przez rok uczyliśmy się, jak włączać dzieci do mediacji. Szukaliśmy też takiego rozwiązania.
In our association, we also tried to deal with mediators' dilemmas, how to be neutral and impartial, being at the same time aware, mindful of the best interest of the child. This is part of our statute. Part of our statutes, the protection of the child against violence, which is something that kids quite often experience when their parents get separated and divorced. Before my friend and colleague Łukasz takes the floor, before my colleague Łukasz takes the floor, I would like to paint the background. I'd like to draw the background. The inclusion of the child in mediation proceedings is not the only initiative which benefits families and parents. We do everything in our power to support children whose parents are getting divorced. This is an ongoing campaign, A Child in Divorce. We kicked off by developing a formula of psycho-educational workshops under the same title, The Child in Divorce. We concluded
My doszliśmy do takiej konkluzji, że
that in order to stir in the parents a readiness for a mediation, we need to offer them something in return, because very often they are unwilling to meet with the other party. They have they have a tunnel vision because the romantic relationship with the other party has stopped. But then when we indicate that the child is there as well, in order for the parents to really and well pay attention to the child after they get divorced, even though the workshop is called the Child in Divorce, we have a module which caters for the child's perspective, as well as for what happens to the adults themselves after they conclude their relationship, how they can cope. We also have an introduction to mediation and to conflict situations. We indicate cognitive traps. The workshop takes place once weekly, 4 hours for 5 weeks. We have a child psychologist, an adult psychologist, life coach, a communications coach, and a mediator, and we believe that this amount of know-how allows the parents to get familiar with what they need to cope with if they need to process things during couples therapy or individuals therapy, if they need to attend therapy together with a child. They can do it. As of 2016, we've had 42 editions of the workshops. We concluded the 42nd one only yesterday, and I must say that after the workshop, very often parents use forms of further support. I graduated in a postgraduate course in emergency psychology. So I have more qualifications to deal with those issues. Very often parents use mediation after the workshop, which shows that we must indicate support for couples in crisis, other than showing them how to cope with emergency situations. This is an introduction. This is an introduction to mediations that include the child in mediation proceedings. And now Łukasz will take the floor.
Witam Państwa serdecznie.
Hello.
Za wprowadzenie. Powiem w paru słowach o w sumie dwuletnim projekcie, który zrobiliśmy.
Just a few words about the 2-year project we have completed, a big challenge, but I would like you to have at least a rough sketch of what we have accomplished. At the very beginning, we had a few people meeting, using the expertise and know-how of the Pelican Association. We launched a project which is based upon this experience and know-how, and on the best practices of the inclusion of children in mediation practices. I would like to indicate some of the aspects that were the pillars of the philosophy, of our philosophy. One of them is this: children can only be effectively protected if we are aware of their crucial and intrinsic role as communication actors who convey verbally or non-verbally the necessary cues to assess the extent of their vulnerability.
Dzieci są
However,
fałszywi
isn't it
konflikcie
that a fiction?
To jest kwestia tylko
Children
jakby co myślimy,
are
teraz uważamy, że
deeply ingrained in the
trzymanie
conflict
dzieci
between
z
their
dala oznacza po
parents,
prostu,
and
że nie dajemy im szansy,
isolating them from this
im szansę
conflict
powiedzieć,
or
wszystkim
separating
innym
them
usłyszeć,
from what's going on in the family may hinder their sharing of their needs and expectations. We need to make children the subject of communication,
Druga kwestia,
or communication actor. One other issue is that we have different inclusion models.
Dziecko włączają w sposób symboliczny, tu się pojawiła taka terminologia angielska,
symbolic,
focus mediation.
Symbolic inclusion or child-focused mediation.
Sposobów włączamy symbolicznie dziecko.
The child is symbolically part of the proceedings through an empty chair, a photograph placed on it. That's one of the ways. We were aware of such modalities. If parents are asked about this kind of symbolic presence of children, usually they disregard the question. So it was not especially effective. Our experience prompts us that the children's inclusion have at least a potential for change, and if not change things literally. As Agnieszka was saying, these are emergency situations, crises, where the child's voice, when hearing the child's voice, may be a chance. I'll say a few words about this in a second. The child has to be physically present, physically included in the proceedings. How do we do that? We heard today a presentation that would show this sensitivity. It's very difficult for the mediator to be the child's advocate. You cannot really wear a number of hats during the mediation proceedings. There are a number of risks. I'm not going to comment on them, but these risks have already been voiced today. You representing a child whose voice the mediator does not know, or knows through the parent in conflict, conflicting roles, weakening of the party's self-determination in proportion to the strength of the mediator's voice as expert and educator, clashes between the world of values of the mediator and of the parties, a challenge to impartiality and neutrality. So here the mediator should strengthen, should empower the parties, and should not be the reference point which the parties only listen to. And also the ethical compass. The more I am of an educator who knows better, we see a clash of two worlds, the world of the mediator and the world of the parties, which presents a number of challenges for the neutrality and impartiality of the mediator. It was clear for us that we want to develop a different model, inviting experts who have requisite skills and know-how on how to make the child's voice heard.
Więc to było takim fundamentem, jeśli chodzi o konstrukcję samego programu.
The foundation of the program.
Sprawę, że to jest
we knew that this is a hard process which calls for preparation, which we tried to do effectively. We followed a Czech example, which was based on the Australian example in turn. We visited a mediation center in Brno in Czechia. On the basis of the visit, we started trainings and simulations using the recording of many elements of the process together with their scenarios. We created a tool, we created a special toolbox, we created documents, reports on the program. These tools are adjusted to the child's age, which ranges from the year of 6 through 18. As you can imagine, the toolbox has to be different. In those two examples, still it should foster the self-expression of the child. We had as many as 27 mediations, varied about the relationship between their parents, the readiness for the judicial process, relations of kids with the parents, and the status of the kids themselves. Very often, the kids wanted to say or cry that they want to talk.
A czasami jakby nie było aż takich dużych obciążeń, bym powiedział. No i stan samych dzieci też był bardzo zróżnicowany.
The status of children themselves was very different. All of these kids were affected by the conflict situation in varying degrees. There were suicidal attempts. There were different children on the spectrum of autism. So again, the context was very diversified. In 22 mediations, we had the inclusion of children from 1 to 3, ages between 7 and 18. Importantly, in Czechia, mediation proceedings include fewer kids, but the longer a conversation is maintained to support parents and children in a state of crisis, the more, the bigger the willingness to listen to the child on the part of the parents. And also good standards. We had a supervision with our colleagues from Brno. We had additional recordings, which later on became our educational material. We spoke about the different models. Let's examine how we do it. Parents learn about the mediation process through a variety of sources. We tell the parents what is possible in the conflict resolution. And we tell them to choose what works for them. Then we meet with each parent separately. If they want to continue with mediation, we take another step. And what happens during this individual meeting, apart from sharing information, we follow the parent. Some parents want to know more about the process or about the mediation role, the mediator's role. Others ask about the inclusion of children. This is what happens during this preliminary meeting, and then mediation proper starts. It is the parents who decide on what they want to talk about. We may have 1 or 2 meetings, and we ask them if they want to have the kids included. If the kids agree to participate in the process, we include a child specialist. The specialist talks with the parents about their role. And the expert asks the parents what is important for them when it comes to their kids, and then we have an introduction to the meetings with the children. The child meets with the expert, meets with the child one-on-one. There are no other people present during the meeting. And actually, all the tools and skills of the specialist are taken advantage of, so that the kid can share their experience. It's no form of therapy or diagnosis. It is to help the child share their observations, thoughts, expectations, and needs. And also the kids, it is the expert who decides what of this is to be transferred to the parents. Finally, the kid is asked whether they want to take part in a meeting with the parents. That's another decision the kid makes. Unlike some of the presentations we saw, we actually put the parents and the kid in the center. We tell them what's possible, and it's they who ultimately make the decisions. In principle, it is the parties, that is, the parents and the children, who decide on the extent of their participation. And then we have a session which includes the child's perspective. Again, if the children want, this is something agreed on between the specialist and the kid, whether the kids are going to be present during the proceedings, or whether they're going to be present remotely, or is it going to be a recording, and so on and so forth. But the underlying objective is for the parents to listen to the kids' voice and be able to talk with them.
Poza pomocą w wydobyciu tego głosu jest taki kawałek.
We also have a specialist's voice,
jest on wyraźnie wtedy zaznaczany.
Which is separated. We make sure that the specialist talks, or we relay the observations of the specialist, of the kids, of the specialist on children. And if no kids are present during the proceedings, the specialist asks the parents about how they want to impart the news of the separation or divorce to the children. It's no therapy, as I was saying. It's a process. The child's voice is a process. It's a part of the conversation between the kid and the parents, and the child needs to get the feedback. After the meeting, 2/3 of the parents agree to continue. Talks continue, but they are intensified, and very often we have dramatic situations. It's really hard to tell you about the process, because nothing will be able to relay to you what the situation involves. One of the examples I can give here is an instance when the father tells mother that I'll go bend over backwards to have the child, to extract the child from your household, and then the child, the father is shown the work of the expert who was working with the kid, and the child is no longer the child doesn't really indicate their father, and it's not a magic process which reverses the crisis situation, but at least because it offers a potential for a positive change. It might be a really significant element towards this change. We see it as a potential for change, and this is how we want to proceed, and how people will use our know-how depends on that. We can say a lot. We're talking about kids from between the ages of 6 and 18. We use different forms of expressions, the written word, the spoken word, drawings, symbols like cards or stones. There are also elements of play like doll houses, or enacting certain histories, the maps, wish maps, or a rucksack or a backpack of worries, and wishing well. This is something we later relate to the parents. Under the project, we wanted to receive some feedback. All the participants had a chance, all the couples had a chance to tell us something about their opinions. Empowerment and recognition, empowerment being shown now. Did mediation help you understand the situation? Did mediation help me decide about further steps? So I was empowered by the process. I can see more clearly, and now I can proceed to the solution. So the process may actually help the parents regain their ground. And the most difficult part of the mediation, that is, yes, I was able to understand the other person better. I was able, and hopefully, that mediation helped the other person understand me and my perspective. It's difficult, and the latter seems even more difficult. To some moderate degree, many respondents
miał poczucie, że druga osoba też mnie zrozumiała. To są takie główne efekty z perspektywy transformacyjnej.
People make towards this in this direction. Their interaction is different, and their solution or the solutions they apply to certain problems are also different and more effective. Very often we are afraid. It was great for me to receive these responses, that the child's participation in mediation helped me a lot, or that the hearing the child's voice helped me, and also the kid was benefited from having their voice heard. We also had some feedback in the written form, say a conversation with the child carried out in a professional, stress-free and pleasant way for the child, who is the most important in all this. The kids were relieved during the proceedings. Say during the meeting with the specialist, the child cried, was in tears, yet they wanted to continue with the meeting with the specialist.
Nawet po prostu wypłakać się przez godzinę i coś tam pozrzucać sobie. I pytamy też dzieci.
And now we also ask kids, how do they assess the meeting with the specialist? They felt heard, supported.
No i parę kawałków właśnie tutaj z tego, co dzieci bardzo
And
różne
just a few things,
informacje istotne,
just a few things. Our kids told us, I came to the meeting because my mom promised me $3. Now the potential for the future. Parents tell us what they have learned through this communication. And one other important element, did people treat one another with respect? Did they feel respected during the proceedings, in contact with us? And this is very important for us. Conclusions. Settlement or agreement is one of the many elements that can happen. Settlement or agreement is something additional which can, but need not need to happen. The process requires solid preparation and a close-knit team of mediators and child specialists. We are responsible for both adults and children, so we need to have a good team of mediators and specialists. Let's not be afraid of the children. Parents, and not only them, as the entire legal system, we often heard about what parents can do to each other in the process. I'm not even talking about the financial costs or emotional costs, which are exorbitant. And parents control the child because they are afraid, very often afraid of what the child will say. There's always this. They try to transfer this tug of war to the procedure. The child is treated in an instrumental way. It's something that can hold the parents and be an impetus for change. It's a unique space to support the whole family in the conversation. Thank you.
Thank you very much indeed, and I'm glad you made it here. I know it's getting late. And ladies and gentlemen, Julia Radanova was kind enough to record a short presentation for us because she's stuck in Munich. I'm sure we can play it for you now. I know that you've returned your devices, but nonetheless.
Ladies and gentlemen, esteemed colleagues, honorable guests. My name is Julia Radanova, postdoctoral student at Mykolas Romeris University, Lithuania. I'm recording this video with a very sad heart, given that I'm right now sitting in Munich airport on my way to see you and actively participate as part of this wonderful conference that is happening right now at Adam Mickiewicz University. Unfortunately, bad weather has hit Germany, and I'm not able to proceed. However, that does not allow me to meet you and greet you in person, but still gives me the chance to offer you my presentation through this recording. So I'm going to share some of the slides that I've prepared, which I have wished that I'm physically being able to deliver to you and meet you in person. The topic I've chosen for today is family mediation challenges within the European Union. the quest for uniform professional standards for practicing family mediation. That will take the most intimate human relationship, namely the family relationship, knowing that it's already strained, if not fractured, and subjected to an adversarial process with lawyers who see themselves as fighters. We need to shift our thinking. We need to start seeing ADR not as an alternative to traditional court system and processes, but as an appropriate dispute resolution. Inspired by the words of Chief Justice Menon and his ideas that have literally transformed Singapore's legal landscape and made it a culture where family dispute resolution is shifting from the traditional adversarial model towards more cooperative and conciliatory one, which is child-focused as well. I would want to continue with the notion that today there's no harmonized professional requirements towards EU mediators that handle family cases. Taking from there, we see today that EU regulations in the field do not resemble. They are patched like the little painting that we see on the screen, and they're very much contained within the borders within which they are taking place, which poses a lot of challenges. And those challenges, we can group them in those 6 categories that mainly represent what we as family mediators are confronted on a day-to-day basis. So on the first note, professional regulations are very much nationally predisposed from the legal regulations that has been adopted in country by country, on a country by country basis. We are seeing a global trend of mandatory mediation models, whereas today 20 from the 27 member states have some sort of a compelled towards parties to participate in a form of mandatory mediation if they are confronted with a family conflict. Then there are different roles of counseling, so counselors and psychological experts have different roles. Child participation is regulated very much differently and depends on the vision that the country has taken. Settlement recognition is not unified at all, and we see different ways how domestic violence is actually treated. Which leads us to the notion, can we, as mediators, perceive ourselves as a service provider under EU law? Is the mediator a service provider? And if so, would that service provider be subjected to what we know as the freedoms to provide services as enshrined in Article 56 and 57 of the Treaty for the Functioning of the European Union? So the first thing we need to clarify is that the term mediator has been given an explicit definition in Article 3, Paragraph 2 of the Mediation Directive, I would use for short. It stipulates that a mediator shall be any third person who is asked to conduct a mediation in an effective, impartial, and competent way, regardless of the denomination or profession of that third person. Taking that definition and adhering to this, the definition that stems from Article 1, Paragraph 1.1 of the Code of Conduct for Mediators, we see that mediators must be competent and knowledgeable in the process of mediation, which means that they have to have the proper training, they have to continuously update their education, practice in mediation skills, they have to have regard to any relevant standards or accreditation schemes as well. So upon pure language interpretation, we can establish that even though there are lack of any specific requirements or professional qualification today to practice family mediation, member states are still allowed to impose their own rules and oblige mediators that practice within that jurisdiction to obtain those in order to be able to provide their services. With this notion in mind, the question is, are there free movement of mediators? Can we use the free movement of services that applies to any service providers and apply it towards mediators. So if we take this notion, there would be three alternative scenarios in which mediators may find themselves in. Firstly, that would be the freedom to travel to provide their mediation services. Secondly, it would be the freedom to travel from the parties in order to receive the service. And thirdly, that would be the freedom of the actual mediation to travel. Within mediation context, this ultimately would translate to the right of mediators to provide their mediation services online or offline to residents of another member state, and the right of parties of another member state to travel to the place where the mediator is located. So if we take the right of mediators to provide their services, that ultimately means that such services would need to be considered as mediations, irrespective of whether they are provided from a member state that has a specific particular regulation or not. This reasoning can be justified by the Directive on the Services on the Internal Market and is supported by the fact that the only exception that explicitly is recognized in the field of legal services is for notaries and bailiffs, which are excluded from the scope of the directive. So basically, all other legal professions, to which one may include also the profession of the mediator, should be recognized as such that fall under the scope of the Directive on Services in the Internal Market. And as such, the latter should be entitled to the free provision of their services in a member state other than that in which they are established, without making the access to or exercise of such service activity subject to any discriminatory treatment or inappropriate measures. So with this basically in mind, we need to take a look now into what are the categories of regulatory models that apply today within the European Union towards mediators. And if we have a close look, we would see three models that academia has sort of came up with. So first we'd have the authorization model, which stipulates for particular professional training and requirements in order for one to be able to be listed as a mediator who offers his or her service. This authorization model is a model that is applicable to Lithuania, it's applicable in Portugal, it's applicable in Bulgaria and many other countries. It basically relies on having a specific training of a given number of hours that each person who may want to be exercising the profession of the mediator would need to have completed, and is subject to an additional registration at public registry for listing those mediators. Then we would see the incentive model of regulatory models that actually involves certain incentives for those who may want to become mediators to acquire additional trainings. The incentive model is depicted and exemplified in Austria, where anyone may be providing mediation services irrespective of the lack of certification or additional training. However, those people who have undergone a specific training can and are recognized as licensed to offer their services in a way that ultimately results in settlement agreements that can be enforced. That's the incentive model. And thirdly, that's the market model, or a model where the state has abandoned its regulatory function and it's left it fully to the discretion of the market to regulate how mediation services are marketed. So in other words, irrespective of what trainings people acquire, it's the market to test who is providing a quality service that is asked for and which members are dissatisfied with that. So today in Europe, we see that this country specifics and these compliances that need to be hit on a national basis render it rather difficult for one mediator to practice under a jurisdiction that's different from where he or she is established. The process of recognizing or accreditation of mediators is hard and actually differs also from country to country. This basically or ultimately results in a discriminatory treatment of mediators in certain member states. I'll use now the example of Lithuania, which is a good way to see that some member states are actually making it or facilitating it, that persons who have been granted the right to provide mediation services So this notion has been confirmed in Lithuania, where we see that persons who have been granted the right to provide mediation services by the competent authority of that state, in accordance with the legislation of a member state of the European Union or a state of the European Economic Area, have unlimited freedom to temporarily provide mediation services in the Republic of Lithuania. So what does that temporary provision of mediation services mean? Actually, it's a term that can be decided on an ad hoc basis. So basically, there are no strict provisions. If we take into interpretation what temporary service provision means under the directive on the services in the internal market, we may come to the conclusion that temporarily actually means providing of the services for a period of not more than 3 months. Would that temporary provision of mediation services, though, truly ensure that mediators can render their services uninterruptedly? And would that be sufficient? That's a rhetorical question that I pose to you to consider. Still, and something that recently the Lithuanian legislator has taken the liberty to do, is to allow Ukrainians or people who have been granted temporary protection and who are being licensed to practice mediation in their own jurisdiction to be allowed also to offer their services in Lithuania. Going back to the further challenges. Today, there's no single mediators market, specifically in family matters. Today, there's lack of unified standards. So that's taken into consideration, and acknowledging the lack of uniform models of how to conduct family mediation, how to include children there, makes various inconsistent requirements possible to happen and take place. Those challenges are not solved on a EU level. They're solved on a national level. But each legislator takes its own path, sharing different set of values and beliefs, and thus making it practically impossible for family mediators to practice from one member state to the other. To confirm that notion and to evidence it with some concrete examples, here is the lack of cross-recognition process as exemplified in the case of Ireland, Portugal, and the Czech Republic. So if one wants to move to Ireland, for instance, and basically start a mediation profession there, he or she would need to have certification to have had already a 60-hour mediation training. But as we already have heard and know about it, certain member states do not even have a requirement. So if that mediator is coming from Austria, where nobody is required, where there's no requirement for mediators to be licensed, he or she would have this as a first hindrance to practice mediation locally. Then that 60-hour mediation training certificate would have to bear another review as to the resemblance of the curriculum of the said training with those of the Mediators Institute of Ireland. One would need to pay additional costs in approximately €500 in order to do this checkup and verify whether he or she may actually be able to be allowed to the market of mediation services in Ireland. Another example is the example of Portugal, where a different mechanism is provided, and it ultimately comprises of a self-declaration before the Directorate General for Justice Policy, in case the mediator shall be working as part of the national institutional framework. However, that self-declaration is not sufficient per se. It needs to come along with a good command of Portuguese in case of permanent establishment. So we see also that the patching of the regulatory is also coupled with the patching in terms of the language competencies a mediator would have, and ultimately allowing a mediator to the national mediation market is contingent on him or she having the command of the local language. Is that justifiable or not? Again, a question for the audience to brainstorm on. Then another example is the Czech Republic. A Czech Republic has a recognition process which requires a certification in another country to have been obtained to verify that that person has the competencies to actually practice mediation. But on top of that, one would need to also prove a master's university degree, a requirement that is not used in some of the countries, for instance, in Bulgaria, where I am from. So that ultimately means that any mediator, regardless of how successful he or she may be in his country of residence, may not be allowed to leave that country of origin and offer his or her services in another member state simply because of the lack of education. All of those are challenges we are faced today, and those challenges simply do not allow harmonization of the subject. What are the solutions, though? Let's focus now on the challenges and come up with specific solutions that may help improve the regulatory framework. Well, first of all, we should perhaps be considering uniform training requirements with synchronized curriculum. And in particular, when we're talking about family cases, we're talking about children and how they are integrated, how their voices are heard as part of a mediation process, we should be thinking about certain protocols, standards that each family mediator actually should have completed in order to be allowed to be named as a mediator. Then there should be fixed standards for the qualification of the mediators, especially given that there is a growing trend of mandatory mediation schemes, and they differ from country to country. And last but not least, we should be starting a cross-border discussion between all member states about the benchmarks of EU mediators' qualities in order to ensure that there's a uniform standard about that. All of those are solutions. They are some proposals, they are recommendations that we as a community should be working on, should be considering, and be part of the active solutions that mediation needs today in order to boost, to blossom, and to truly live up to the expectations we all are hoping for. With this, I thank you for the attention. And again, I want to apologize that I'm not right now with you in beautiful Poznań, enjoying this wonderful conference. Thank you for the attention.
Dziękujemy bardzo. Proszę Państwa, wiem, że dzisiaj pobiliśmy wszelkie rekordy, ale teraz na koniec dla wytrwałych.
I know we've set the company's record for anything today. However, last but not least, we have Professor Tabernacka, who is such a frequent guest at our conferences. She might actually have her domicile at this address.
Może, chociaż czasami studenci nasi, którzy przestali być studentami i chcą się dostać gdzieś, gdzie łatwiej na aplikację radcowską, robią różne sztuki.
Sometimes our students, our alumni, do all kinds of tricks to live on the premises of the faculty. I know that the subject is difficult. I'm after a leg surgery. I need to stand up because I've been sitting so long for
dziękuję Państwu
for
z tej
this.
kanał.
Could we launch the presentation, please, ladies and gents? I'm really thankful to my colleagues from the Pelican Association.
Więc tak, Szanowni Państwo, bardzo Państwu dziękuję, bo myślałam, że moja prezentacja to będzie, że tak powiem, cichy, słaby.
So once again, many thanks for being here. Actually, what you said in the Pelican Association, you actually showed empirically that my theory works, and I'm really glad that we see one another today. Let me start with Hitchcock, who said that at the very beginning we have everything that leads us to the conclusion, and then the tension only grew. I'm in favor of including children in mediation proceedings.
Kolegom z pracy, że im umyje samochód, kiedy skierują sprawę do mediacji, i zawsze żądał, żeby dzieci przyszły na mediację, na rozprawę sądową w sprawach rodzinnych. Akurat ja dzisiaj będę mówiła o przemocy. No i mówił, że ma takie połowiczne.
We had many examples of judges who wanted to have children in proceedings. Well, often justices wanted to meet with the children who were going to be affected by the proceedings. They wanted to see the physical relations, the topography of the room. So if the parents smeared the reputation of each other, the judge knew what the decision would be. And these judges who insisted on the child's participation in mediation proceedings persuaded me to do it. Well, I was wondering before the lecture which hat to wear, the parents, the mediators, or the child's. However, for me, it's really important to be in the shoes of the child, and we cannot do this without hearing the parent. One sociological aside, we all have been children. Not all of us are parents, but what we are depends on two processes. One is social integration, and the other is enculturation. These are unconscious processes. Children learn by seeing, by observing. To my mind, there are self-presentation mechanisms. We try to educate our kids, and the situation is as follows: when we walk briskly somewhere with our kid, and all of a sudden there is the red light, what do? We enter the road. The kid says it's red light. And now, what do? We stop. We stop and retract our steps, because this is something we had been trying to instill in the child all along. This is an argument in favor of having kids in mediation. Now, what do we do when we have domestic violence cases? The longer I live, the more certain I am that only the person who knows, who says that they knows about what they do. Well, violence is violence. Simply, I will show you research on that, and there is no justification. What is justice? What is violence? Violence is aggression when we deal with an imbalance of power, physical, economic, or social. even if it's physical violence. Very often we wouldn't deal with physical violence if the perpetrator didn't recognize that they can actually use violence.
Mówię tutaj, będę mówiła o wszystkich rodzajach przemocy. My oczywiście najłatwiej jest zobaczyć
I'll try to talk about all kinds of violence. This is institutional violence.
Kiedy mamy przewagę relacji, dowolnych relacji, możemy sobie pozwolić także na każdą z tych innych.
Remember that when we have an imbalance of any relations, we can also deal with all kinds of violence. Mediators don't live in a bubble. As a professor, I sometimes do live in a bubble, but then when I get on a train, I'm extracted out of my bubble. But violence is egalitarian, and you may see this as a cliche. But one mediator from Wrocław did something like that. She has 3 sons, and in one of her sons' school, she had a Christmas party of wishes without the teacher, and then the kids wrote their wishes to the parents on the Christmas tree. The kids felt empowered, respected, and appreciated. The parents shed many a tear under the Christmas tree, and the principals of the school were afraid of who wrote these demands. This is an excellent exercise. It opens the sores in family life and social life, and when it comes to domestic violence, we cultivate the culturally conditioned sweeping under the rug thing. This is a book, Scream Quieter, which scream quietly or the neighbors will hear. Nothing has changed for the past 50 years or so. That's the question I also ask to my students. Is the family a safe haven, a safe asylum? After a time, first the respondents react with surprise, no, but after a time, when I think about this topic, it's the question of power and control. This is a powder keg, you may think. Our success in life depends on whether the others will do what we want of them, and it's easiest to exert some kind of pressure on others of different sort. I'm sure you know the types of perpetrators that Aaron Pizze spoke about. A person who's in denial, a perpetrator who's in denial, one who minimizes the harm done, and so on and so forth. Now, what about the scope of domestic violence? Let me tell you that I had a number of colleagues, a number of group mates when I was a student, and I had thought that domestic violence is basically heterosexual games. Actually, it's a permanent phenomenon, independent of all the other criteria that you can see here. Violence takes many shapes and sizes and can be present irrespective of someone's sex, religion, sexual orientation, social and economic status, race, and place of residence. It's only a question of tools. I love the Istanbul Convention, because Istanbul is so far away from Europe that some people say that it's not our convention, and besides, Turkey is no longer a state party to the convention. Well, if you hear the term the Istanbul Convention, part of the electorate will be against it. So here we have the victims. These are the kinds of violence. And one other thing is important. We need to have vitamins as mediators. Violence has deep-seated ramifications. The whole community is affected. It affects customary violence. I once sold an apartment because we had dealt with rowdy neighbors that we couldn't cope with. We had to move houses, and that's why the only way to put a stop on violence is to deal with the perpetrator. You cannot eliminate violence, and this is something we can communicate to people during mediation, unless someone takes responsibility for it. I indicated to you 3 types of perpetrators. They always they can always justify their action. It's not them who are to be blamed for anything. One of the kids, one of the parents can have a high social status. So we won't be able to inflict any suffering on this individual, but we can indirectly inflict pain on the other individual who has less connections, and we can inflict punishment on them through the child. This is something I would like to show to you with regard to the anti-discrimination or anti-violence convention. The child who also observes domestic violence acts is also a victim. A witness is also a victim. The child may be a direct victim of domestic violence as a delegate of the family. The kid may be a boxing whipping boy, or maybe indirectly affected. The slides, if somebody would like to use them, I had a number of movies, a number of videos for my students, different social campaigns from around the world. This is a UK movie about corporal punishment for kids. I once invited for a conference one of the biggest human rackets I know, my colleague Carolina said that I suspect that, like most of you, I was abused, physically abused in my childhood. I was beaten up by my parents, and she said once that when she was on a holiday with her parents in Bulgaria in the 70s, she was 4 and her brother was 3. They went on a walk together, and once they came back, they were scolded by the parents. And one of our colleagues said, "But where were your parents when you were on a walk alone?" It's the parents who take responsibility. So why do parents beat the kid? It's very often a reactive reaction. The parent is played out when they have kids. When I had my first kid, I really couldn't sleep a wink for the first 3 years. I was really tired, and in principle, violence is always reactive. We learned from the parents that, well, let's imagine a situation, you drive at 30 kilometers per hour, and the policeman stops you and uses the baton against you. What do? We complain about the behavior of the policeman. But this is also what happens in parent-child relationships. There is a sociological category of justified violence. In Poznań and Wrocław, we understand this very well. I ask my students when is violence justified. Socialism was defeated a few decades ago, so I have a question to my students. I had a project recently. Bilateral stereotypes. Mediations have a whole sack of stereotypes to work with. One of the authorities in social approach to the family divided the parents into authoritative families. We might have members of the family who beat up the kid. Violence. So I said I would never send my kid to boarding school because there's a lot of discipline there, and there is violence. Suffice it to read Harry Potter's novels. Okay, there are some myths connected with domestic violence. We all know it's untrue. However, what is really painful is that when we deal with domestic violence, these people might love one another, but they do not love each other well. We need to have someone who will take action. This is a study I encourage you to follow. This is quite an old research. It's over 20 years ago. Role of genotype in the cycle of violence in maltreated children. In England, blood was taken from around 1,500 male toddlers because they had been suspected of something with, well, Assassin's Creed is based on the research. And this study confirms the interactive role of genotype and society in fostering specific social roles. If we want to love our children, and not to be related to them through the Stockholm syndrome, we mustn't beat children. There's proof that if children were abused at a young age and they have a very low level of oxidasis, then they will be asocial human beings.
konfliktu z prawem, ale jak się dziecko sprawowało w szkole, czy prowokowało bójki i robiło inne rzeczy. Jeżeli mamy wysoką oksydazę, no to prawdopodobnie nie wyrośniemy na osobę aspołeczną, ale proszę Państwa, to musielibyście Państwo...
Well, actually, we would have to have more than just a blood test. So once again, do advertise this study because it's hard scientific evidence which shows that beating kids is very, very bad. Now, what's good about the Convention of the Council of Europe on the prevention and elimination of violence against women and domestic violence? We do have culturally conditioned violence, for example, the sati custom of having sake. We used to have the sake coffee from India in Poland, where widows are burnt on the pyre together with their husbands. Well, I'm glad to be European. I'm very Eurocentric, and this convention sets a good example. I really deplore the fact that Turkey is no longer part of the convention. The European standard is something that was born out of blood and conflict. All the witches were burnt on the stake, and here it's not witches but women.
To, co mamy teraz. I teraz to, co jest bardzo istotne, to to, że tutaj mamy po prostu gotowy wzorzec.
We deal here with a system of anti-violence convention.
Państwo, organy państwa i NGOsy. Jestem wielbicielką BABY z Lubuskiego Stowarzyszenia na rzecz przeciwdziałania przemocy wobec kobiet. Dokładnie tak. Także proszę Państwa, i NGOsy w Polsce,
NGOs in Poland are a great thing. They do work.
I teraz proszę Państwa, to jest definicja z
konwencji. This is the definition of domestic violence in the convention. Some of it has been
bardzo dobrego i po trochę mamy to też w prawie, ale nie wiem, czy mogę głośno mówić na ten temat. Mam nadzieję, że nie mamy tutaj piątej kolumny jakiejś.
Incorporate into the law. We do have the most modern definition of the family in the world. This is what I tell my students. If you rent an apartment together through the principle of subsidiarity, we belong to the same household, or we belong to the same family.
Chyba że całe państwo, prawda? Zależy, jak to wygląda w konkretnych zadaniach publicznych.
Importantly,
bardzo istotne to
the convention respects violence against former partners, and this excludes
działania typu jestem Zagłoba i będę mieć koncept, prawda?
Situations like I'm Zagłoba and you're going to have a conceit.
Sprzedać lufę albo coś innego w ucho, żebyś sobie nie myślała, prawda? Na takiej mniej więcej zasadzie. Także, proszę Państwa, to jest
bardzo ważne. This is very important. We don't need to live together. We are a family, and if there were any ties between us, if there is violence in the household, because very often the delegates are not only children but also old parents. This is what we managed to do at the Pelican. The mediator is no wizard.
Mediacje muszą być w przypadku przemocy domowej, bo
Mediation has to take place in cases of domestic violence, and this is part of emergency reaction, emergency strategies. I encountered this book some time ago, and I do recommend it. We are lacking in systems of holistic emergency intervention, crisis intervention, where mediation is only one of the many, if a quite significant element of combating violence. Now, what are some of the challenges for the mediator? Let's have a look. On the left-hand side, I don't know what the pink color here is. These are the stages of crisis intervention, and this is the question for the mediator. At which stage should we launch mediation? As soon as possible?
Może nie wtedy, może mediacje pomogą zdefiniować stronom problem, prawda? To może się bardzo, bardzo przydać. Proszę Państwa, nieważne kiedy, lepiej późno niż wcale.
It doesn't matter when we start, better late than never, but the sooner
kiedyś. Natomiast ugoda mediacyjna, jeżeli do niej dojdzie, może nie dojdzie do ugody
the mediation settlement, once it is reached,
zobowiązania jest ewidentnym, najważniejszym efektem interwencji kryzysowej, w której doszło do mediacji. Bo tak jak Państwu mówiłam,
tangible effect of the crisis situation and the mediation in the crisis situation, because unless the perpetrator admits their guilt. I collect very interesting examples because my research shows that very often honorary compensation is of paramount importance. I got from my students a picture with a banner saying that somebody here in this block of flats was abusing his wife for so many years, and this is what it looks like. And this is a problem that is a research administrative law, and I'm a researcher of the public sphere. I have dealt with a lot of situations of the NIMBY type. I'm actually sued by the city of Wrocław for some action.
Zobaczymy, co się dalej stanie. W każdym razie, proszę Państwa, proszę zobaczyć. Konwencja wprowadza tylko i wyłącznie zakaz stosowania
And the convention assumes a ban on using mandatory alternative dispute resolutions or judicial decisions. Now, ladies and gents, generally speaking, to my mind, violence is not...
Generalnie, w mojej ocenie, przemoc nie stanowi przeciwwskazania, natomiast nie wolno...
Countermeasure for mediation, you don't negotiate the conditions of violence, even though I met one case when a victim of domestic violence said that they were ready for mediation. And one of my colleagues from Wrocław wants to publish an article on the inefficiency of isolation measures with respect to perpetrators of domestic violence, and the victims of domestic violence were ready for, when they are ready for this, they are the package which can holistically solve the problem, even though they might take longer. However, let's have a look at this slide. It's unacceptable.
O, urwało się, nie będę cię bić, tam miało być napisane, nie wiem jak to się stało, oparła się pani o klawiaturę.
I don't know why I don't have it right here on the slide. The scope of mediation, something what is really important. What about compensation or remedy? What about a therapy for the perpetrator of violence? Now, this is something that the mediator
Proszę Państwa, to nie jest zabawa, to nie jest gra w klasy mediacji.
does.
W przypadku mediacji
The neutrality of the mediator is no game.
Mediator mimo wszystko, gdzie są
In
takie
situations where we deal with
może nie do
violence,
końca powinien oczywiście nie
domestic
może brać
violence,
z
the
jednej ze
mediator
stron,
cannot
ale
really
musi
take the
używać
side
relacji
of one of the
symetrycznej
parties,
na pomocy
but
wszystkich do
they
tego,
should
proszę Państwa,
offset
w końcu jak
the
to zrobić.
imbalanced
Teraz, proszę Państwa,
relationship between the parties.
moich badań to
I
są
will
tak
show
zwane
you
badania
later what
podwójne.
kind of
Niektórzy
tools can be
uważają, że
used.
bardziej
We
seksowne
have
są
longitudinal studies,
powiedzenie badania
even though
longitudinalne. Ja używam nazwy podłużne, bo lubię tego typu kwestie. Proszę Państwa, mediator może zrobić bardzo ważną rzecz, która będzie miała wymiar indywidualny, trochę tak jak
we might use also another term. In penal law, we say that we have specific and general prevention. This regulation has been in place in Poland since 2010. I did my research back then. I do hope to be able to publish the results of my research. The regulation is important in that
powiem, co to jest kontratyp. Kontratyp wyłącza karalność z uwagi na coś. I myśmy mieli do tej pory kontratyp uprawnień rodzicielskich, czyli proszę
we cannot
Państwa,
exclude certain types of perpetrators. For example, just a smack in the face was not seen as violence. Now we have a ban on the corporal punishment. I asked my students who are young people who want to have a credit for my classes. Generally, I didn't ask them to whether they had been beaten up as kids, but these are the average results for this year. Is it accepted? Is it tolerated? Now,
że mniej więcej jest pół na pół, czyli jednak rzeczywiście młodzi ludzie uważają, że
it's really 50-50.
A tutaj Państwu pokażę, ja zawsze staram się badać język. Więc
well, I always try to
eufemistyczne, językowe,
examine language, so I wanted to hear some euphemisms related to domestic violence.
Wzmacniająco, cechujące negatywnie. I teraz proszę zwrócić uwagę, zdecydowanie więcej jest tych kompensujących, prawda? Zwłaszcza właśnie to wszystko.
There are many more compensatory euphemisms than negative ones. Here we deal with a number of Polish slang terms for the different slang forms for domestic violence. Some are humorous.
Ale moją pierwszą prezentację na ten temat właśnie
My first presentation on this was titled Bęcki in Polish. Now, to set things to order, do you see this? That's the problem of power, of authority, which shows what is the law. The one who beats has the power. We spoke about authoritarian families, but the inclusion of children in mediation, please remember that parents know that they cannot beat their kids, saying that the mediator that they beat the child may smear the reputation of the parent. However, it's a real task for the mediator, because these people also, well, remember, these people still love each other. However, in a situation where domestic violence takes place, it's a different matter. If somebody is weak, they may also be very bad. The person who is very weak just parentizes the kid. And look at what happens. Here we have some sociological, psychological measures that impose certain things on the child.
Dziecko do szkoły, pamięta, żeby to dziecko było czyste, przejmuje odpowiedzialność za tą rodzinę. I wreszcie, proszę Państwa, zjawisko, na które mi zwróciła uwagę taka wrocławska pani psychiatra dziecięca, pani Magda Koterwa-Kniaś.
A psychiatrist from Wrocław drew my attention to the fact about the invisible loyalty of kids. They say that, well, the parent had the right to beat them because I didn't wash my hands, I was this and that.
To jest fundament. Może jest słaby, ale jest jakikolwiek. I teraz, proszę
At
Państwa,
the end, I would like to propose a mediation model. Violence is violence. What we need to do is to bravely counter violence, and my son is being raised in such circumstances.
Polecam Jagodna, to jest takie schronisko.
We were once in the mountains.
Rodzina, którą nazwaliśmy oprawcy.
There was one family whom we called perpetrators from Silesia. They had a small toddler.
Mamusia go tak trzymała, a tatuś dawał mu łyżką.
Mother was holding him, and father was feeding him with gruel.
Całkiem niezłe. W każdym razie, proszę Państwa, on powiedział tak.
And my son said, Mom, you need to do something about it. You cannot leave them like that. Now, what we did was we lay in a dark place, and we told them that they couldn't do this. They couldn't feed their kid like that. And then my son did something else. We were in Czechia.
Zwłaszcza jak ktoś lubi Tolkiena, tam jest dokładnie jak u Tolkiena, hobbity się czają za każdym krzakiem. I tam z kolei, proszę Państwa, ja nie wiem dlaczego, ale ja to często widywałam w Czechach, taki maluch się wyrwał.
And we saw a toddler who would trot up to some chasm, and mother smacked him on the cheek. Anna Wesołowska, who does a lot to prevent corporal punishment against the kids, said that they would work together with the Ombudsman for Children to create certain structures of educating parents.
Wyjdzie z tych swoich przemocowych kolejn, można zacząć mówić cokolwiek innego.
You cannot enclose these parents. This is the exercise we do with my parents, with my students.
Więc jeżeli ja będę, a studenci zawsze pchają,
students always push.
Z nimi działa. Więc jeżeli będziemy na kogoś
napadać,
if
we attack someone, there will be a reaction, and this reaction will be like that. Two more words, obviously, about the commentary. I'm really glad you said something, that there are no spectacular results. It's not magic. It's painstaking. We often say that something was a milestone in our life. Someone said that nobody witnessed the collapse of the Roman Empire. It took a few centuries for the Roman Empire to dissolve, and this also happens in the case of domestic violence. The mediator has to make sure that if the system doesn't work, that mediation is in the emergency reaction. It has to be on board in cities and towns which are...
I mediator musi tam być umiejscowiony jak
capitals of powiats or
Proszę
counties.
pamiętać, że to jest kwestia
What else?
stanu dziecka dzięki uprzejmości
It's also the welfare of
Miałam okazję mówić o właśnie dobrostanie dziecka 2 tygodnie temu w
of
Wilnie.
children. I spoke 2 weeks ago about the child's best interest in Vilnius. The child cannot be overburdened by the mediation, so it's also the question of form, and the child has to meet with the mediator with some support, but it cannot look like a staged thing. We need to have supporting entities and protecting entities. And 2 words about psychopaths. We have something about psychopaths. And let's remember, psychopath only differs from a regular person that they are not afraid. The perpetrator has to start being afraid. It would be worthwhile to work with the prosecution authority.
Umysłowo, że tak powiem, prokuratorów, którzy potrafią na stosownym spotkaniu wyjaśnić.
I know a few prosecutors who are able to explain to the parties that they really
Dokładnie. To generalnie co do zasady, już kończę, to co do zasady
with the perpetrators, you need to stop the mediation, and this is how I would like to finish my inspiring talk.